And if, let's see, you're going to be posting the rosters?
Yes, I will do that. I'm going to start the live stream right now. And then. Okay.
Not that any of you care, but the participants who are watching, and I guess it's live stream now too. I was, discussing whether I should have a virtual background. And my ultimate decision was, if you don't like my basement, well, that's tough luck. Since I'm a retired judge, I don't get to sit in a courtroom. So you get what
you're stuck with my house too. So the first roster that came up is the plaintiff, and the second roster, the plaintiff is Michael. The team name is Michael. The second one that's coming up right now is the defense, and this is Team Stanley.
Great. I guess I have to turn the classical music off too. There we go.
And for the students, my phone number is posted in the chat and the scoring panelists. If anybody needs anything, as soon as we're done with the preliminary matters, I will shut off my camera and save the bandwidth, but I will be monitoring chat and available for you guys if you guys need anything.
Thank you very much. Okay, it looks, could I have a video on my scoring panelists, please? And I need to change my name so it says presiding judge here, just so you know what's going on. There we go. See. And Ms. Porter, and we're waiting for, oh no, I've got Mr. Ingram, and for Ms. Busby. Let's see, do we have her yet? Oh, there she is. Ms. Busby, if you could turn your, if you're there, if you could turn your video on briefly. She may be just off camera for a moment. Ah, there we go. Okay. Just so that everyone will know this, but that's all right. My procedure is to ask each of you at some point here before we begin to introduce yourself to the participants, just so they know who they're dealing with. And I'll do that here in a moment. But if you, each of the four of you, would take a look at the trial rosters and see if you have any conflicts, and if you do not, just indicate as such, and that will be passed along. Then Amber can pass that along that we don't have any conflicts, assuming that's the case. I do not have any on these lists.
Did the scoring panelists all receive the trial roster? Or did I just send that to Judge Wheeler? Okay, I think I just sent that to Judge Wheeler. I'm having technical issues. I think my brain is trying to leave for the weekend, so I will send that to everybody right now. Hang on just a second.
It's in the chat room, so it ought to, everybody ought to be able to access it.
Relations.
Oh, you just chatted directly to me. I see. Okay, sorry. And while we're waiting for that, Mr. Ingram, we're going to do something a little different than we did in the first trial. And you've got a lot of glare on yours. Do you have an open window right next to you there? Have you got a shade you can drop on that? If not, it's okay.
Yeah, I'll see what I can do about that.
All right, scoring panelists, now I have it correct. Everybody should have it.
Much better, yep. And just so that everybody knows before we start, what we're going to be doing differently than any of the virtual trials that I've done, the 4 in Denver, the 4 in Arapahoe, and now these 4 at the state competition, is that, let me get my, turn around with my camera earlier and almost had a terrible problem of my camera dying, so I'm not going to touch it again once I get it centered. What we're going to do as far as the 4 of you scoring panelists is that the suggestion was made as to whether or not the scoring panelists should be have their video activated during the entire trial. And some of the presiding judges thought that was a great idea. Some of them thought it was a terrible idea. One person came up with a solution that I think is a wonderful compromise. What we're going to do is have the 4 of you have your cameras activated during opening and closing, so that the jurors can, or the attorneys can talk to you. Otherwise, the attorneys do not talk to you during a regular trial, an in-person trial. They only address you during voir dire, which we don't have, and during opening and closing. So I think it's appropriate that they be able to see you while they're doing their opening and closing. When we have witness examination, I'll remind you to blank your video. Your audio will be off all the time, except those times when I ask you to introduce yourself, and of course at the end when we have comments. So that's what we'll be doing a little bit differently. Do we have any, anybody have any conflicts with our panels? Great, okay, so we're all set on that end, and Amber will tell us as soon as she gets to go ahead from everybody else that we can start.
We're good to go. Thanks, team.
Okay, thank you. What I'm going to do now before we start the actual trial is to have each of you of our scoring panelists introduce yourself to the jury. Ms. Porter, if you'd go first.
Of course. My name is Lauren Porter. I use they, them pronouns. I am not a lawyer, but I am this is my 8th year of mock trial. So I'm a college senior at Colorado College.
Senior, wow, good, congratulations. Mr. Ingram.
Like Counselor Porter over there, I am not a lawyer, but I did mock trial in high school here in Colorado, and I also compete here at Colorado College.
What year are you?
I'm a junior. They've got me beat just by a little bit.
All right. And Ms. Busby.
Hello, I am an attorney. I'm a defense lawyer at Nathan M. Mayer. I primarily practice in the area of insurance defense representing healthcare providers.
And Ms. Song.
Hey everyone, I'm a 1L right now at CU Law. I did mock trial in high school and college. I was both an attorney and a witness.
Go Buffs. Unfortunately, they got knocked out of the NIT in the first round. Too bad. All right, if I could have all of our participants on the screen, please. Including the timekeepers. Let's see, we're still missing witnesses for the, looks like the Stanley team.
Here are our
witnesses are seated behind us.
I'm sorry?
Our witnesses are seated right behind us.
Oh, so I won't see them on the camera right now?
Yes.
Okay. Oh, I see them. I see. Okay. Whoa, way back there. All right. Well, we'll deal with that in just a moment. All right. Who is lead counsel for the plaintiff, the Michael team?
Your Honor, I am the lead attorney on the Michael team, and my name is Lee Pavetti.
Ms. Pavetti. Okay. And lead counsel for the Stanley team, the defendants?
Your Honor, I am lead counsel. I'm Caitlin Brennan.
Wait a minute. Oh, wrong page. That's right. Never mind. There we go. Ms. Brennan. Okay. Now, let me just get this out of the way right now. For the attorneys for Stanley, how are you going to use the camera when you have opening, closing all of your examination? Right now, I can barely see you. Are you going to have a different setup when we start?
Your Honor, we ask that we be permitted to move about our virtual well in front of the counsel table.
Okay, so you'll just move the camera up and move it to each person who is talking?
No, Your Honor, we will physically move in front of counsel table to perform examinations and speeches.
Oh, okay, great. So we'll be able to see you that way, okay?
Yes, Your Honor.
Great, okay, that's fine. All right, other than that, it looks like everything is gonna work now. Okay, give me a moment here to I'm going, let's see here. Before we get into specifics, I want to ask lead counsel a few questions. Ms. Pavetti, for the plaintiff, how are you going to be dealing with exhibits? Are you going to be screen sharing?
Your Honor, during preliminary matters, I was going to bring that up, but I could bring that up now if you would like to.
No.
Or do you want to do
No.
preliminary matters currently?
Well, it's not, I look at this separate than the preliminary matters. This is a technical matter.
Of
I want
course.
to talk about if you're going to do screen sharing, how you're going to do it.
Yes, sir. So what we were planning on doing is having co-counsel share while entering the exhibit and answering all the foundation questions, and then asking to enter it. But I know
That's all I need on the technical part is you're going to have a third, you're not going to do it. You're going to have a third party do it.
Yes, Your Honor.
Good. That's a nice, smooth way to do it. Ms. Brennan, for the defendant, how are you going to handle this?
Your Honor, pursuant to Rule 7.4, all witnesses should have a copy of all exhibits and their own affidavit in front of them. So when we are referencing them prior to admission, we will not be screen sharing. Once the exhibit is admitted and published to the jury, then we will screen share the exhibits.
Okay, so at some point you will screen share.
Yes, Your Honor.
Okay, here's how I want you to do it. I understand that you would, for identification, you would not be screen sharing, but that means I can't see it. So I want you to screen share when you introduce the exhibit for identification. I simply have a standing order to the jury that they're not to consider it unless I admit it. And since, we're not a real trial, it doesn't matter. But I want you to screen share when you introduce the exhibit. That way I can see it, because otherwise I can't. So if you would have the screen share immediately, and then if I introduce it, I will simply instruct that the jury can now consider it. Is that fair enough?
Yes, Your Honor, we can do that. Our trial technician will be handling exhibits.
Great, thank you very much. Okay, now, as to the timekeepers, and I think I have the timekeepers on here. For timekeeper for the plaintiff, which is the Michael team, I can see you right there in front of that nice brick blue wall. Are you going to be posting the chat on time, or are you going to be showing, screenshots?
I'm going to be posting in the chat, and then once the time is up, if they do reach 0 on the timer that I have set, I'm going to unmute and say so. So
Great,
just
fair enough.
get more time.
Now, timekeeper for the, what's the other team called here? The defendant, the Stanley team. How are you going to be doing this?
Yeah, I'm going to be doing essentially the same thing. I'll have the time and I'll be posting it in the chat, and the opposing counsel's timekeeper and I can confer after each segment just to make sure we're on the same page.
Okay, good. So you're both doing it almost exactly the same way. All right, now if you you may or may not all have been listening initially, but we're going to be doing a first for me, at least in the times that I have done these trials. We're going to have the scoring panelists, your jury, on the screen video, not audio, but video during opening and closing. And they will be off screen then, no video, during witness examination, just so that you know that they will be up there. They'll be up there to begin with, then they'll be gone, then they'll be up again at the end. And if I forget to say that, to tell the panelists to reactivate their video or to shut their video down, somebody remind me, because it's only the first time I've done it this way, but I think it's a good way. I'm anxious to see how this works and what your reaction to it is, which I will probably ask you when this trial is over. Just so that you know, I am a retired district court judge, 18th Judicial District, sitting in Arapahoe for a little over 14 years. I was in civil for about, roughly 6 of those 14, well, 6 or 7 of those 14 years. But before that, for 26 years, I was a civil trial attorney litigating cases almost exactly like this: product liability, did some insurance carrier defense, bad faith defense, things like that. Plaintiff's work in the employment area, but I did a lot of this product cases, so it's very familiar to me. Okay, let's go ahead and start. Gotta find, Ms. Pavetti, for the plaintiff, do you have all your witnesses and attorneys assembled?
Yes, Your Honor.
And are you ready for trial?
Yes, Your Honor, but a few preliminary matters first.
Just a moment. Ms. Brennan, do you have all of your attorneys and witnesses assembled?
Yes, Your Honor.
And are you ready for trial?
Yes, Your Honor. However, we also have a few preliminary matters to attend to.
Of course. Ms. Pavetti, you're up first. What can I do for you as far as pretrial matters?
Your Honor, we would like the record to reflect that the trial rosters have been posted in the chat.
Yes, they have.
And we would also like the record to reflect that the stipulations agreed to by the parties are already part of the trial record according to Rule 4.7.
And they are.
We would also like the record to reflect that opposing counsel has shared and has received copies of our witness statements and exhibits.
And for the, let's see, Ms. Brennan, have you received the witness statements and the exhibits?
Yes, Your Honor.
From the plaintiff. Thank you very much. Ms. Pavetti, anything else?
No further preliminary matters at this time, Your Honor.
Thank you. And Ms. Brennan, any matters for you?
Yes, Your Honor. May we make appearances for the record?
We're going to do that here in just a moment.
Yes, Your Honor.
Any other matters?
Yes, Your Honor. The defense has made efforts to be in a setting with as a good internet connection. If at any time you cannot see or hear us, please feel free to interrupt us and let us know.
If there are any problems, and I was going to deal with that in just a moment. Let me go ahead and deal with that in a moment.
Yes, Your Honor.
But it will be acceptable to you, I'll guarantee it.
Yes, Your Honor.
Anything else?
We also ask that the court and scoring panelists put their Zoom view into gallery instead of speaker mode. As you can see, our setting is a bit unique, and if it's not there's a chance you might not be able to see us during our presentations.
Okay, I'm experiencing exactly what you're talking about. I didn't quite understand what you were saying. So one more time.
We ask that you put your Zoom settings into gallery view instead of speaker view, so that you can see everyone with their cameras on at a given moment instead of just the speaker.
I always keep it that way, but I think that is for the, I do toggle back and forth, and I'll allow the scoring panelists to toggle back and forth at their election. Sometimes it is important to see someone up close, full screen. Most of the time I leave it on gallery, but every now and then I'll toggle up just to see someone up close. But I understand your point. It will be up to both the court and the scoring panelists as to how they toggle back and forth. Anything else?
Yes, Your Honor, we just wanted to make sure that you're aware that you may not be able to see us at all times, even though our cameras are both on.
Okay, we'll deal with that if it happens.
Yes, Your Honor. We ask for permission for the CEO of Lush Fertilizer, Blake Doncourt, to be our advisory witness and to be seated at council table for the duration of trial.
That's fine.
For the record, all witnesses will not be sequestered pursuant to Rule 5.3.1 of the Rules of Competition.
If they are experts, they do not need to be sequestered. Otherwise, lay witnesses effectively are sequestered. They may not actually be out of the room, but for the purpose of the trial, we'll consider that they are.
Your Honor, pursuant to the Rules of Competition, there is no sequestration of any kind allowed.
Oh, well, if that's the case, I wasn't aware of it. I've had I did the Denver competition, the Arapahoe competition, and one round of this one, and no one's brought that rule up. If that's the rule, then so be it.
Yes, Your Honor. May my trial technician provide a copy of the stipulations, jury instructions, and the court's pretrial ruling to the court via the direct messaging system of Zoom?
Effectively, you may do that. I don't need them. I do have them, but we'll assume that you have sent them, yes.
And may we also provide the jury instructions to the jury, given that they are already incorporated into the record?
Actually, not yet. Not till the end of the trial. There are a very, very few judges in this country that give jury instructions first. That's a kind of a debated issue in judicial conduct on whether the jury ought to be given the instructions at the beginning of the trial. My practice as a judge was I did not, because the trial changed the issues so much. Almost every trial, the issues change, and the jury instructions just aren't accurate by the end of the trial if you give them out in the beginning. But in this case, we will not be doing that until the end of the trial.
And just to clarify, Your Honor, opposing counsel in their pretrial asked the record to reflect that the jury instructions have already been incorporated into the record. Is that the case, or is it not the case?
Well, incorporated into the record, if you want to read from a jury instruction during your either your opening, your closing, or during questioning of a witness, it wouldn't be in a question of a witness, but in opening or closing, I'll allow you to use the instructions, yes, but not in questioning a witness.
Yes, Your Honor. Unfortunately, we were not able to confer with opposing counsel prior to the start of trial today, but we would like to add one stipulation.
Additional stipulations?
Yes, Your Honor.
Okay, go ahead, slow down just a little bit though. Again, because you're so far from the microphone, I'm having a little trouble hearing, but go ahead.
Yes, Your Honor. We would like to stipulate the admission of Exhibit 1, as it is not in dispute that that Exhibit 1 is the packaging of Lush Fertilizer in today's case.
That's the pack. Okay, and you're on the defense side. My guess is that plaintiff probably won't have a problem with that. We'll let's see, Ms. Pavetti, will you stipulate to the admission of Exhibit 1, the product label?
We have no issues with it, Your Honor.
Good enough. Exhibit 1's in. Thank you. Any others?
My trial technician will post the updated stipulation in the chat.
So we've got exhibit, the single addition is exhibit 1, correct?
Yes.
Good enough. Anything else?
We ask for permission to move about the well during our statements and speeches and examinations.
As long as you're close enough to the camera so we can see you, I'll allow that. But you're
Yes.
going to have to move, you're going to have to move up quite a ways.
Yes, Your Honor.
And if I find that it's a problem where we can't see you, I'll tell you, okay?
Yes.
Good
At
enough.
this time, the defense is ready to proceed to trial.
I'm sorry.
At this time, the defense is ready to proceed to trial.
Great. Okay. Let's get into the rest of the technical part of this case before we start with opening. Let's see here. I want to remind our audience, our streaming audience, that although you can see this, please don't record it. Please don't take screenshots of it. It's just not appropriate because the Colorado Bar Association has the limited right to take photographs or videos of these presentations. Also, for our streaming audience, if you are associated with another team, with the limited exception of having one of your children in 2 different teams, which does happen on occasion, if you're not associated with either of these teams, Stanley and Michael, please do not attend this session. It is not appropriate for competitive reasons. As you know, there will be no recesses granted unless on 2 conditions. One, or 2 exceptions. One is a medical emergency. And if you or a member of your team has a problem, let me know immediately. And I'll take care of that as far as having, giving you the time to deal with that issue or however else we need to do. But if there's any medical emergency, please let me know. The other is for technical problems. If there is a technical problem, it'll be fairly obvious to everyone, I think, and time will stop. There will be times when there is simply a breakup of someone's testimony, someone's question, someone's answer, where it's broken up and whoever is answering or giving a question will be asked to do it again because there was a break in the connection. If we have a significant number of those, I will unilaterally make a decision towards the end of the case to add time to both sides because it wastes, at no fault of anyone, it wastes the limited time that you have to do your job here. And I may add 30 seconds or a minute. The first trial we did in Denver, we had to add 15 minutes because the entire system crashed. So please be aware that time will be kept very strictly unless I indicate that you're going to get some more time because of technical difficulties or other issues. But if otherwise, there'll be no recesses that add time. Any disputes that arise out of the competition here, you're well aware of what the rules are. Some of those disputes may be resolved by me as the presiding judge. Some of them may have to be taken up after the trial is over with the Bar Association who's sponsoring this. Some of them may be dealt with through cross-examination if there's a dispute, where you just cross-examine that they've gone outside the rules. I think you're probably more aware of those rules than I am or our scoring panelists are. If an issue comes up, I'll deal with it and we'll address it then. I've indicated time requirements will be strictly enforced unless I indicate that additional time may be added if we have technical difficulties. I'm going to ask plaintiff first, Ms. Pavetti, if you would introduce yourself, ask your co-counsel to introduce themselves, and then your witnesses, please.
Yes, Your Honor.
Whoop, Ms. Pavetti, we lost you.
Your Honor, opposing
Oh.
counsel, and members of the jury. My name is Asia Hallbeck, and I'll be providing the closing argument for the plaintiff, the cross-examination of Blake Doncourt, and the direct examination of Dakota Weirs. My witness would now like to introduce herself.
And could
Your
I get,
Honor.
this is your witness introducing herself? I see how you're going to do it. Gotcha. Go right ahead, ma'am.
Your Honor, my name is Jada Askew, and I am Dakota Weirs.
My co-counsel would now like to introduce themselves.
That's fine.
Your Honor, opposing counsel, and members of the jury, my name is Christopher Cooper, and I will be providing the opening statement for the plaintiff, the cross-examination of Skylar Weirs, and the direct examination of Carson Durst. My witness would now like to introduce herself.
Your Honor, my name is Alyssa Springs Pena, and I am Carson Durst.
Thank you.
My co-counsel would now like to introduce themselves.
Your Honor, opposing counsel, and members of the jury. My name is Tiffany Pavetti, and I will be conducting the cross-examination of Dr. Devin Williams and the direct examination of Dr. Casey Rogers. My witness would now like to introduce herself.
Your Honor, my name is Sierra Bourne, and I am Dr. Casey Rogers.
Thank you. And Ms. Brennan, if you could introduce yourself, your co-counsel, and your witnesses.
Yes, Your Honor. Good afternoon. My name is Caitlin Brennan, and together with my co-counsel, we represent the defendant, Lush Fertilizer Incorporated.
And Ms. Brennan, raise your right hand so I can tell who I have. Yep, there we go. Okay, thank you.
I will be presenting the opening statement, conducting the cross-examination of Dakota Weirs, and the direct examination of Blake Doncourt.
Thank you.
Good afternoon, Your Honor. My name is Bailey Burton. I will be conducting the cross-examination of Dr. Rogers, the direct examination of Skylar Weirs, and conducting the closing argument.
Thank you.
Good afternoon, Your Honor. My name is Angela Hernandez. I will be conducting the cross-examination of Ms. Carson Durst, as well as the direct examination of Dr. Devin Williams.
Thank you.
Can everyone now introduce themselves?
Yes, they may.
Good afternoon. My name is Hannah Feeney, and I am Dr. Devin Williams.
Good afternoon. My name is Mason McCarty, and I am Skylar Weirs.
Good afternoon. My name is Marcus Vincent, and I am Blake Doncourt.
Thank you. Let me, because your format for the defense is a little different than I've seen before, I just want to make sure what we're going to have when we have witness examination. Will we have two cameras, or are we going to have one camera covering both the witness and the attorney?
There will be two cameras, Your Honor. The audio will be going through one.
Okay, so we'll have another screen pop up here for your witnesses?
Yes, Your Honor.
Gotcha. Okay. All right. Just wanted to make sure I knew how it was going to work. Okay. I'm going to ask all participants, please, including our scoring panels, but all participants and the timekeepers to activate their cameras, because I'm going to swear you all in here. First, you can leave your audio off if you assent to this oath that I'm going to give you, group by group. Merely nod your head. I'm going to ask all of the attorneys first. Raise your right hands. Attorneys, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? Now, all six witnesses, if you'd please raise your right hand. Witnesses, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add any material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? Great, thank you. Now, our four scoring panelists, if you'd raise your right hands, please. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition? Thank you. Now, if the scoring panelists may leave their video on, I'd like the attorneys to drop their video. Well, we won't be able to do that for the defense, I guess, will we? No. But, well, everybody else just leave your cameras on then, because I do need everybody's on, including timekeepers. Because I can't separate attorneys from timekeepers for the defense, I'll just have everybody on here. I neglected to swear in the timekeepers. If the two timekeepers would raise your hands, please. Do you solemnly swear that you will keep time in accordance with the rules and procedures in the mock trial competition? Thank you. Okay, now, my procedure is that I will swear in all of the witnesses as if they were coming to the stand. That saves about 10 minutes of swearing each of 6 witnesses in. So rather than do that, I'm going to swear you all in so that all the attorney doing direct exam will have to do is call you to the stand and your testimony will begin immediately because I will have already sworn you in. So if I could have all witnesses raise their right hand. Do you solemnly swear or affirm under penalty of law that the testimony you're about to give today in this matter will be the truth, the whole truth, and nothing but the truth? Thank you. Now you're all sworn for your testimony in the future here. See if I have anything else. I don't. We'll have everyone drop off except the timekeepers. I'm sorry, the timekeepers, the scoring panelists, and grab my sheet. It appears as though Mr. Cooper is doing opening for the plaintiff. Mr. Cooper, you're up. And there we go.
Thank you, Your Honor. Sorry, we were having a technical difficulty. May I proceed?
Yes, you may.
Thank you, Your Honor. Your Honor, opposing counsel and members of the jury, how much is one life worth? That, ladies and gentlemen, is the question we are here to answer today. Dakota, the plaintiff, believes Lush has caused her cancer, non-Hodgkin's lymphoma. She was only 14, trying to make a little bit of money working for a company called Haven Landscaping when she was exposed to Lush's products. Now, she has cancer, non-Hodgkin's lymphoma to be specific. Her life is basically ruined. She can't do any of her favorite things, such as play the piano and be active in the community. Dakota loved playing the piano and would play day and night and anytime she got the chance, and even got a scholarship to Juilliard, the top art school in the country. Dakota was active in her community and was always trying to help somebody. 20 years old. Isn't that the age that you're supposed to feel free? Like there isn't worry in the world? Now, because Dakota has non-Hodgkin's lymphoma, she can't do that. She can't go out into the world and be free. Even help around with basic tasks around the house. Members of the jury, we have what is called a burden of proof in this case. We have to prove to you that the defendant manufactured a fertilizer product containing a chemical compound known as Drufo. The defendant was negligent by failing to exercise reasonable care to prevent the product from creating an unreasonable risk of harm to people who might reasonably be expected to use the product in the manner the defendant might have reasonably expected. The plaintiff was one of those persons or people the defendant should have reasonably expected to use the product. And the plaintiff had damages that were caused by the defendant's negligence while the product was being used in the manner the defendant should have reasonably expected. You'll hear many testimonies today from many different witnesses. One of them is Dr. Casey Rogers, who ran a private study into Drufo to see if it was carcinogenic in humans and found a link between non-Hodgkin's lymphoma and Drufo use. Another witness you'll hear from is Carson Durst, a former Lush scientist that had concerns about the safety of Drufo and brought it up to the executives of Lush, and they said to sweep it under the rug. You will also hear from Dakota Weirs herself and how this disease has impacted her and why she believes that Lush caused her cancer. Opposing counsel may try to convince you that Dakota was negligent in her actions. If you believe their arguments, but also believe that Dakota was less negligent than the defendant, your verdict must be for the defendant. How much is one life worth? The plaintiff believes that we cannot put a price on a single life, or a group of lives for that matter. But in damages, we are asking for $6 million. $3 million for the emotional trauma and effect that it has had on Dakota Weirs and her family. $3 million for physical damages such as medical bills and medical bills. And schooling, sorry. As well, how much is one life worth? We believe we cannot answer that question. Thank you.
Thank you. And Ms. Brennan, opening statement for the plaintiff. For the defendant, sorry.
Yes, Your Honor. However, I do have an objection. Although I couldn't make an objection during the opening statement, I would like to let the record reflect that the opposing counsel just asked to consider economic damages in the pretrial motion. We are only permitted to argue for non-economic damages.
And there were economic damages for medical bills, and my understanding is that's already been resolved. So non-economic damages are the damages in this trial. You're correct.
Yes, Your Honor. Your Honor, can you see me well enough in this position?
Keep coming. That's pretty good. Thank you.
Just to clarify, since the admission of Exhibit 1 has been stipulated to, may I reference and hold up the exhibit during my opening statement?
Of course.
May it please the court?
Yes, you may.
Misguided, misinformed, and misused. We're here today because, unfortunately, Ms. Weirs has a type of cancer called non-Hodgkin's lymphoma. Many of you probably know how heartbreaking it is to hear news of a friend or family member's cancer, or have even experienced it yourself. So it's not surprising that Ms. Weirs is now looking for answers. Why her? Why now? And what caused this debilitating disease? But this misguided lawsuit was fueled by misinformation and Dakota's own misuse of the products she worked with at Haven Landscaping. Lush Fertilizer Incorporated is a fertilizer manufacturer. For the last 20 years, they have truly been helping to make the world a better place. The CEO and founder, Blake Doncourt, will tell you how Lush was created as and is a safer and healthier alternative than other mainstream fertilizers. He will tell you how Lush followed all of the proper safety precautions to ensure their customer safety, including placing a warning label on the packaging of their product. The plaintiff's twin brother, Skylar Weirs, will tell you how Dakota misused the various products she worked with at Haven Landscaping. Despite being a child at the time, she worked with products clearly marked keep out of reach of children. Despite being instructed to wear an N95 face mask or respirator, Dakota didn't wear one. And despite being told to wear protective clothing that covers exposed skin, Dakota chose not to. Somehow, out of all of the dangerous chemicals that Dakota worked with during her time at Haven Landscaping, she chose to blame Lush Fertilizer, the one product that was created as a safer alternative to the others. that Lush Fertilizer can't be responsible for Dakota Weir's cancer? Because Lush Fertilizer is safe. Dr. Devin Williams, a toxicology researcher, will tell you all about that. At the end of the day, Haven Landscaping is responsible for hiring a child to work with products that were never meant to be worked with by children. Haven Landscaping is responsible for not monitoring their employees to ensure that they are wearing the proper protective equipment. Haven Landscaping and the companies that manufactured other chemicals that Dakota worked with should be on trial today, not Lush Fertilizer. Both parties have the burden of proof in today's case. This means that there are two steps when it comes to reaching your verdict today. First, the plaintiff must prove by a preponderance of the evidence, which means that it's more likely than not that Lush Fertilizer was negligent in failing to exercise reasonable care with their product. Within that, Lush had to know that their product was dangerous and know that any risk associated with the use of that product was not obvious to the average user. If you do find that Lush was negligent, you must also consider whether or not Dakota Weir's cancer was partially or even fully a result of her own misuse of the products that she worked with. We are confident, though, that at the end of today's case, you will see how Lush Fertilizer is in no way responsible for Ms. Weir's cancer. As you listen to the evidence, I want you to keep in mind three important questions. First, did Lush Fertilizer fail to exercise reasonable care with their product? Second, could Lush Fertilizer reasonably have expected that a mere 14-year-old child would be working with their product? And third, could Lush really have expected that a consumer like Dakota Weir's would not use the explicitly recommended protective equipment? If you can answer any one of those questions with a no at the end of today's case, the plaintiff has failed to meet their burden and you must find in favor of the defense. The plaintiff asked you to ask yourself what one life is worth. And the answer is that it's priceless. That's why Haven Landscaping and the companies that manufacture dangerous chemicals should be held accountable, not Lush Fertilizer, whose only goal was to keep people and the environment safe. As sympathetic to Dakota's cause as you might be, you cannot let that sympathy influence your decision today. This misguided lawsuit was fueled by misinformation and Dakota's misuse of the products she worked with. Misguided, misinformed, and misused. At the end of today's case, my co-counsel, Ms. Burton, will ask you to return the only just verdict, that of not liable. Thank you.
Thank you. The scoring panelists will now drop their video, and we'll have the first witness for the plaintiff. Is Ms. Holobeck, are you doing direct on the first? There we go. Ms. Holobeck will be doing direct. Ms. Burton will be doing cross, and you may call your first witness, Ms. Holobeck.
Your Honor, just to clarify, I'm Ms. Brennan, and I will be doing the cross-examination.
Oh, you're right. Sorry. I went straight across on my list here. Ms. Brennan will be doing cross-exam. My mistake. Ms. Holobeck, you may call your witness. There we go.
Your Honor, at this time, we call Dakota Weir's to the stand.
And Ms. Weir's, you've been sworn. Ms. Holobeck, you may proceed.
Hi, Dakota. I know this will be hard for you, so at any point, if you need to take a break, let me know. Please state your name, spelling the last for record.
Dakota Weirs, W-E-I-R-S.
How old are you?
I am 20 years old.
What do you do for a living?
Nothing really.
Do you have a job?
Unfortunately, I do not.
Why not?
Your Honor, may I be heard?
I'm sorry, the objection is?
Your Honor, this is more prejudicial than probative pursuant to Rule 403. As we've already
But before you go into it, what's the objection?
More prejudicial than probative pursuant to Rule 403.
403. Okay. And now you may explain a little bit.
As we've already established, economic damages cannot be argued in this case. Whether or not Dakota Weir's has a job goes towards economic damages, not non-economic damages, which are at issue. Therefore, it's more prejudicial than probative and not relevant to discuss that issue.
Ms. Holobeck?
Unfair.
Your Honor, I'm just clarifying my next question. These questions lay foundation for my next question, which is why does she not have a job? Establishing why that is, leading into her diagnosis of non-Hodgkin's lymphoma.
I'm going to overrule the objection at this stage of the testimony. This could not only be, the fact she doesn't have a job could not only affect her economic situation, but also her non-economic mental status and her well-being. So I'm going to allow it at this point. Overruled. Ms. Holobeck, you may continue.
Your Honor, I ask that you place a limiting instruction on the jury so that they do not consider it as economic damages.
So ordered. Fair
Yes,
enough.
Dakota, why do you not have a job?
Due to my condition, I can no longer function properly in society.
Why are you here today, Ms. Weirs?
I'm seeing less fertilizer because their products gave me cancer.
Why do you believe Lush Fertilizer is responsible for this?
Well, when I was 14 years old, I worked at Haven's Landscaping, and I was responsible for fertilizer. And one of the main fertilizers I used was Lush Fertilizer.
Is there something about Lush Fertilizer that makes you think that it gave you cancer?
Yes, their fertilizer contains Drufo.
How do you know that you were exposed to Drufo?
I'm sorry, can you repeat the question?
Of course. How do you know that you were exposed to Drufo?
I use Lush Fertilizer's product, which contains Drufo.
Where did you often use this product, Ms. Weirs?
I often use this product in large office buildings, usually in the lobbies.
How did you find out about Drufo?
Well, there was a story about Lush Fertilizer's main ingredient, Drufo.
Please refer to Exhibit 1, and Your Honor, I request that my co-counsel share on their screen a copy of Exhibit 1.
You may publish it. Yes, it is already admitted.
What is depicted on this Lush Fertilizer label?
It shows the ingredients are Lush Fertilizer, but no warnings.
Why is no warning label on the fertilizer packaging important to you, Dakota?
When you have certain warnings, then you can take certain precautions.
Why do you believe your illness was not caused by other environmental factors?
I have a twin, and we basically participate in everything, minus the fact that I worked at Haven's Landscaping and she did not. But had she had worked at Haven's Landscaping with me, she would have developed non-Hodgkin's lymphoma too.
Objection, Your Honor, may I be heard?
I'm sorry, the objection is?
This is improper expert testimony pursuant to Rule 702. If the witness just testified that her brother would have contracted non-Hodgkin's lymphoma had he been in the same conditions as she was, the witness cannot know that unless she was qualified as a medical expert or a toxicologist of any kind, but she's not been.
Ms. Holobeck?
Your Honor, if I may, Ms. Weirs was merely giving her opinion on why her illness was not caused by other environmental factors. She was not trying to provide any expert testimony on if that had actually been the case.
Ms. Brennan?
Regardless of whether or not it is an opinion, that opinion still requires expertise in a certain field, which Ms. Weirs has not demonstrated.
Your Honor, if I may, since it is an opinion, you do not need expert qualifications to make an opinion on whether your sibling would have gotten the same environmental conditions as you.
In the context of the testimony from this witness, from the plaintiff, obviously it is lay testimony. She's giving a lay, she is giving a lay opinion based on her observation of a similar circumstance of other people that have been exposed to other things. So I'm going to allow it as a lay opinion, does not need expert testimony. Overruled. Ms. Holobeck, you may continue.
Thank you, Your Honor. Now let's talk a little bit about your time at Haven Landscaping. Were there any safety recommendations at place at Haven?
Yes, there was.
What were these safety recommendations?
We were technically told to wear long pants, long sleeves, and gloves, but these were recommended.
Were these safety recommendations ever enforced?
No, they were not.
And did you follow all of these safety recommendations?
Sometimes I did, and sometimes I did not.
During the times you did not, why did you not follow all of them?
Well, it's too hot outside, and my other co-workers were wearing their protective clothing. They were wearing t-shirts and shorts, and I followed along with them. But had I would known that this would have caused my horrible condition, I would have taken further notice and precautions.
Now let's talk a little bit about non-Hodgkin's lymphoma. What is non-Hodgkin's lymphoma?
It is a cancer.
And what are your symptoms?
Extremely painful lymph nodes. I have frequent weight loss, chills. They're horrible.
Is there a cure for this cancer that you know of?
Unfortunately, there isn't.
Now let's talk a little bit about the impact non-Hodgkin's lymphoma has had on you. How has this affected you?
Well, now that I have my condition, I can no longer do things I love, such as playing the piano. Ever since I was a young girl, I loved to play the piano, and it brought me closer to my grandfather. But now that I have my condition, I can no longer do the things that I love.
Has non-Hodgkin's lymphoma had a financial impact on you?
Of course it has. My father has to pay extremely expensive medical bills, and on top of that,
Objection, Your Honor, may I be heard?
And I'm going to make the same ruling we made before. This could have an impact on her psychological well-being. The jury will be instructed that it is only to be considered for non-economic damages, not economic damages. Same issue, same ruling. Thank you.
Yes, Your Honor.
And Ms. Hollebeck, you may continue.
Dakota, would you like me to repeat the question?
Yes, please.
How is non-Hodgkin's lymphoma, has it had a financial impact on you?
Of course it has. My father has to pay expensive medical bills, and on top of that, I have a scholarship at Juilliard, one of the best schools in the country, but I can no longer participate in the scholarship because of my condition.
Dakota, if you feel comfortable enough to answer, how much is your life worth to you?
I feel like my life is very important. I love to be a 20-year-old, doing things that 20-year-olds do, but because of my condition, I cannot do that. I would love to live life normally as it was, volunteering and playing my piano, but I can no longer do that.
What do you hope to accomplish in suing Lush Fertilizer?
Well, I hope that others do not get this horrible condition that I have. Well, if I do get compensated for my condition, I would love to donate to the finding of the of non-Hodgkin's lymphoma, the cure of it.
Thank you, Dakota. No further questions, Your Honor.
Ms. Brennan, cross-exam.
Yes, Your Honor. Ms. Weirs, you don't think you will ever be well enough to pursue a career in concert piano, do you?
No, I do not.
But people do recover from non-Hodgkin's lymphoma.
There is a high survival rate. Yes.
So you are aware that you could still become a concert pianist?
I'm sorry, can you repeat the question?
You are aware that you could still become a concert pianist?
Technically, yes.
Now, during your time at Haven Landscaping, you were a landscaping technician, right?
I was, yes.
You spread grass seed and fertilizer?
I did.
And you were only 14 years old at the time that you were hired on initially, correct?
Yes,
Now, besides working with Lush fertilizer, you also worked with other fertilizers, right?
I did. Yes.
But you didn't provide a list of the other chemicals you used, did you?
No, I did not.
So the jury can't know of any health effects associated with the use of those other chemicals, can they?
I'm sorry. Can you repeat the question?
The jury can't know that those chemicals aren't dangerous.
Technically, yes.
And the jury can't even see warnings that might be on the packaging of those products, can they?
No.
So you're telling me that you're blaming Lush fertilizer when you didn't even look into the other chemicals you used?
Yes.
I'd like to talk about your time working with the chemical more in depth. You were supposed to follow certain company guidelines, right?
Yes.
You were supposed to wear facial protection?
I was, yes.
You didn't do that though, right?
Sometimes I did not, but most of the time I didn't.
And as you said, Haven Landscaping didn't monitor its employees to make sure that they were wearing this facial protection, did they?
No, these things were recommended.
You were also supposed to wear protective clothing that covers exposed skin, right?
Not really. These were recommended, not enforced.
Have you ever said that your boss told you to wear protective clothing?
Yes, he did.
And yet you didn't wear that protective clothing.
Sometimes I did, and sometimes I did not.
Have you ever said pretty much everyone, including me, wore shorts and t-shirts?
Yes, my older co-workers were wearing pants and t-shirts.
And so were you, right?
Yes.
And I'd like to direct your attention to Exhibit 1, which my trial technician will screen share. On the bottom right-hand corner, it says, wear protective clothing that covers exposed skin, doesn't it?
Yes, it does.
And it tells you to use a N95 face mask or respirator, right?
Yes.
So you knew that you were supposed to wear all of this protective clothing.
Yes, I did, but it was hot outside and my other co-workers were wearing their protective clothing.
Right, and you still didn't.
No, I did not.
Thank you, Your Honor. I have no further questions. My trial technician can now take down the exhibit.
And Ms. Pavetti, no, I'm sorry, Ms. Holobeck, redirect.
Yes, Your Honor.
Lost my place, sorry. There, go right ahead.
Hi, Dakota. Why did you not follow all the safety recommendations?
Well, it was hot outside and I was 14 years old and the other workers were wearing their protective clothing. But had I would have known this would have changed my life so drastically, I would have taken more careful precautions.
Do you regret not wearing your protective clothing?
Of course I do. I have to live life not knowing if I'm going to survive or not and going through these horrible side effects of my cancer.
You mentioned there was a high survival rate for your cancer. Is your cancer still difficult to manage?
Yes, it is. With the treatments that I go through, I have horrible side effects that are extremely painful and make me very weak.
And do these side effects make it difficult for you to play the piano?
Yes.
Objection, Your Honor, may I be heard?
I'm sorry, the objection?
This is outside the scope of my cross-examination pursuant to Rule 613. I didn't ask anything about Ms. Weir's current state.
I do not recall any questions about the piano in Cross. Ms. Holobeck, is my memory faulty?
I believe so. I do believe you mentioned, I believe in her first couple of questions, opposing counsel mentioned if Dakota would be able to play concert piano again. Yes.
Ms. Brennan, do you acknowledge that?
Yes, Your Honor, I was objecting to the questions about Ms. Weir's current state, physical health.
I'm sorry. You're so far away from the microphone. Hang on a minute. You're just going to have to speak a little bit slower.
Yes, Your Honor, I wasn't objecting to the questions about the piano, but the questions about Ms. Weir's current physical health.
Current physical health. Okay, and all right, Ms. Brennan.
Your Honor,
I mean, Ms. Holobeck, I'm sorry.
Yes. I do believe opposing counsel mentioned about the high survival rate and if Dakota felt like she would be able to recover enough for it. And I feel like that gives some leeway into inferring about her current state, as she was asking if her current state she'd be able to recover from.
Ms. Brennan, does that explain it, or do you still maintain the objection?
I maintain the objection as I was simply talking about recovery and not Dakota's current state.
I believe the area is open enough based on those questions to allow that that area. So overruled. I understand the objection, but I think the area is open enough. Ms. Holobeck, you may continue. If you need to re-ask the question, go ahead.
Yes, Your Honor.
Yes. Dakota, would you like me to re-ask the question?
Yes, please.
Considering your current state, do you think you'll be able to recover from cancer?
It's really not up to me to decide. I don't really know.
Okay, no further questions, Your Honor.
And Ms. Brennan, recross on those issues?
I have no recross, Your Honor.
Thank you. And Ms. Weirs, that concludes your testimony. You are excused. Thank you very much. And we'll now have the next witness for the plaintiff. Is this Mr. Cooper's witness? It is Mr. Cooper's witness. And that we will then have, let's see, this is Durst. We'll have, and who is doing cross-exam?
I'll be, Your Honor. Angel Hernandez.
Mr. Hernandez, okay, great. Just so I know, I've got toggling back and forth between speaker and gallery so that I can see you a little better there at that table. If I had thought of this, I would have tried to see if we could move that camera a little closer, but this will work too. So in any event, Mr. Cooper, you may call your witness.
Your Honor, before we begin, we would like to ask if the court would like that we request that opposing counsel step closer to the microphone so that we can hear objections.
That's just what I was talking about. Let me. I don't want to spend a lot of time on this, but because it's an issue, let's see if what we can do. And I'm going to address Ms. Brennan, your lead counsel. So let me ask you directly. Is it possible to move that camera a little closer so that when you're doing direct, for instance, you'll be standing about the same distance from it, which is fine, but the camera would be closer for the objections of that table. Is that possible?
Your Honor, given the way our camera is set up, we don't have much leeway to move the camera any closer.
Okay, let me ask this then. Mr. Cooper, is your screen on gallery or on speaker?
We can hear them. We were just wanting them clear, but as they cannot move, we will accept those.
Okay, and I understand. I've kind of compensated here by toggling back and forth between gallery and speaker. It is a little easier to understand when you can actually see them closer. You can see their mouth moving and I found that over the years and even in the courtroom. But we'll see if we can work this out. All right. So your time will begin. Call your witness.
Thank you, Your Honor. The defense calls Carson Durst to the stand. Please state your name, spelling the last for the record.
Carson Durst, D-U-R-S-T.
What do you do during the day, Carson?
I am a lead product developer at Terrace Greenway.
And did you have any previous jobs?
Yes, I was a lead product engineer at Lush Fertilizer Incorporated.
And to be clear to the jury, when did you leave Lush Fertilizer?
In December of 2006.
All right, and going back to the beginning, why did you choose to work for Lush Fertilizer?
May you repeat that?
Why did you choose to work for Lush Fertilizer?
Well, I hadn't initially planned to work for them, but I had been told that since I hadn't had a job lined up, that I get some strings pulled and that I would have a job.
And did you have a family connection when entering the company?
Actually, I did. I knew the Doncourts very well. They were like a second family to me, and so that led to there being a family connection with getting my job, but that is where that family connection had ended also.
So it didn't help you get after your internship. So it didn't help you get your real job?
No, it did not.
And when did you start with Lush?
In June of 2003.
And were you assigned a certain position when you were hired?
Yes, I was assigned to the research and development team.
And when did you become a product development engineer?
Roughly 3 months after I had started my internship.
And were you still on the toxicology research and development team when you were promoted?
Yes, I was.
And did you help on any specific projects while working at Lush?
Yes, I was tasked with finding the chemical compounds that comprised in Drufo.
And did you know what Drufo was going to be used for?
Yes, Drufo is used as a bonding agent and fertilizer to help with the soil and crops and fertilizer.
And what was your first task related to Drufo?
I was tasked with researching the chemicals that comprise in Drufo, and I had actually found a study done in England.
What were your results besides?
You broke up.
Were there any results? So you just found the study from England?
So because I've been tasked with finding the chemicals that comprise in Drufo and finding whether it had, since we were still in the testing stage, to find whether it had harmful effects or whether it had been good. And so I had found a study done in England on rats about Drufo and its possible carcinogenic effects.
And did you document the finding of this article?
Yes, I did, in my book.
Your Honor, with your permission, I request that my co-counsel share what has been remarked as Exhibit 3.
Exhibit 3 may be posted for identification.
Have you seen this document before?
Yes, this is the study done in England on Drufo.
And when did you find this article?
If I think about it correctly, it should be June 10th of 2003.
Very specific. Is it common procedure to log a finding like this?
Yes, we would all, everyone would log their findings of their research in their lab notebooks, and we would give it to our product manager, Mary Langley, and she would read all our reports and gather them into a finding and make a final report.
So Gary Langley also had access to your lab notebook?
Yes, she did.
Is this document true and accurate to the best of your knowledge?
Yes, it is.
Your Honor, we move to enter Exhibit 3.
As to Exhibit 3, Mr. Hernandez, any objection?
Yes, Your Honor. As Exhibit 3 is a study out of England that Carson Durst merely documented in their lab notebook, I have 5 individual objections to make to this exhibit. Would you like to take those one at a time or all at once?
Well, first of all, I'm going to need to, at least temporarily, I need to drop the exhibit so that I can get a bigger picture of you. There we go. Okay. Go right ahead. What are the objections?
Your Honor, I would begin with hearsay pursuant to Rule 801, given that this document is an out-of-court statement that is being used to prove the truth of the matter asserted. The truth of the matter asserted being that a component of Truffaut may be carcinogenic in rats. Furthermore, given that this study mentions results of studies done before it, there is a second layer of hearsay added to it, making it hearsay within hearsay pursuant to Rule 805.
Okay, let's go one at a time.
Yes, Your Honor.
So the first objection is under 801 that it's being offered for its truth. Mr. Cooper.
Your Honor, this document is hearsay, but due to the hearsay exception 8036, this is a business record, and I can elaborate further if the court would like.
Well, you're going on a business record of the company, and as an exception to hearsay, Mr. Hernandez, what's the response?
Your Honor, pursuant to Rule 8036D, Carson Durst has not laid the foundation that they are the custodian of this exhibit and that they created it, and as such, it cannot fall under the exception 8036.
Because why?
Pursuant to Rule
My understanding is this was part of the report, correct?
Yes, Your Honor. However, as Carson Durst was not the one who conducted this experiment and is not the sole custodian of said document, she is not able to elaborate to it based on a record of regularly conducted activity.
Mr. Cooper, you can have the final word.
Excuse me. This witness did find this article and did know its source and did testify to that when I was laying foundation for it to be entered.
Or I think there is some justification in the plaintiff's position here that if it is hearsay, that it would fall under the business rule exception because the company incorporated it into part of its records into this report. But I will tell you otherwise, this ain't hearsay. It just isn't. It's not being offered for its truth. At the moment, the only testimony is that it is being offered as part of a report. Not that the report's true, just that it was assembled. So far that I've heard, this witness hasn't testified, and unless he testifies later on that this is true, as opposed to this is part of the report I submitted or that our group submitted, it's just not hearsay. So either way, it comes in. Objections overruled. Mr. Cooper, you may continue.
Your Honor, if I may, I had 3 additional objections to make to this exhibit.
Oh, I'm sorry. You're right. Yes. And the next objection then.
Pursuant to Rule 702, Your Honor, this is an improper expert opinion. Seeing as Carson Durst has not been qualified as an expert in today's case, they lack the education, experience, and otherwise specialized knowledge to speak on the content or derive any explanations from Exhibit 3.
All right, based on my ruling just a second ago, this is not being offered for its truth, so it's not his opinion. It is merely, this is what I gathered, this is what it said, and I submitted it to the company for its action. So it is in reference to his job submitting a report to the company. Not that it's true or false, merely that the information was given to someone else to make a decision. Now that person may be relying on it for its truth, but not this witness. So what's the next? That's overruled. What's the next objection?
Your Honor, I would also object 602, a lack of personal knowledge. Again, seeing as how Carson Durst did not conduct this study, they do not have the proper knowledge to testify about its content.
Mr. Cooper?
Your Honor, a moment to confer with co-counsel.
Yes, you may.
Your Honor, this is relevant and is she does have personal knowledge on this because she worked with this product, she worked with Drufo, she was testing on Drufo, and she used this article to cross-check her research and to, as you will hear in my witness's testimony, to have Lush start a study into if it's carcinogenic in humans.
I'm going to reserve ruling on this. I'm going to allow the evidence to go forward. If I hear, again, based on my initial ruling, if I hear that this witness starts to give an expert opinion, which so far he has not, but if he starts to give an expert opinion, that this objection will raise its head again without you even standing up. I will stop it. But so far he has not. So the testimony will go forward. We'll see what else he has to say. Mr. Cooper, you may continue.
Your Honor, while I understand that the objections have been overruled, I ask that a limiting instruction be placed to only make an opinion off of this exhibit and not testify to it being carcinogenic in any capacity.
Well, so far he has not. We'll see what he says. I'm not going to be proactive and limit testimony unless he says something that is objectionable. So far, in my opinion, he has not. So we'll continue. Mr. Cooper, you may, if you need, I can't remember where we were. I can't remember if there was an answer given or not to your last question. If not, you may re-ask it.
Thank you, Your Honor. My co-counsel is pulling the exhibit back up.
There we go.
Sorry, Your Honor. May we now enter this exhibit?
Yes, exhibit 3 is posted to the jury. Thank you.
Thank you, Your Honor. What was your reaction after reading this article?
That if it had been carcinogenic in rats, that there was a possibility it could be carcinogenic in humans as well.
And does the article suggest that?
Yes, in the last paragraph of the conclusion section, it has mention of its possibilities in young children and adult women.
And I would like to ask you to define that you've used many times. Can you please explain what carcinogenic means?
Yes.
And the objection is?
Improper expert opinion, Your Honor, pursuant to Rule 702.
And the what exactly is the expert opinion here? What is cancer?
Your Honor, I anticipate that the witness is about to go in depth as to what carcinogenic means, and as they lack the education, experience, and training, again, they are not allowed to testify about that definition.
Your Honor, if I may.
Mr. Cooper, yes.
I'm just asking her to explain it how she uses it, as well as she is not an expert, and we are not asking her to give expert testimony.
Or if she can give a lay opinion about what cancer is, I'll allow it, but let's not get into the medicine on how it occurs, what causes it, things like that. I'll allow that.
Thank you, Your Honor. So just to explain to the jury, what is carcinogenic?
Something being carcinogenic means it can give a possibility of it causing cancer.
Thank you. Let's talk about your research for Lush. Did your research into Drufo end after this first study?
I'm sorry, may you repeat that? You broke out.
Yes, let's talk about your research for Lush. Did your research into Drufo end after this first study?
No, it didn't actually. I received email about how we would conduct a second study into Drufo to see if it had been carcinogenic in humans.
And were you still an intern when you started the second study?
No, I had not been.
And how did you receive word that you needed to start a study into humans?
Through an email from my boss, Gary Langley.
Your Honor, with your permission, I request co-counsel share what is pre-marked as Exhibit 4.
Exhibit 4 will be posted for identification.
Have you seen this document before?
Yes, this is the email sent to me.
And who is the writer of this email?
Gary Langley.
And who's that?
He was my boss.
And do you happen to remember about what time of year you received this email?
Well, it does say that it had been sent in September of 2003.
And is it true and accurate to the best of your knowledge?
Yes, it is.
Your Honor, we move to enter Exhibit 4.
Mr. Brennan, any objection to Exhibit 4?
Your Honor, I have 3 objections to make to this document, starting with authenticity. While I understand authenticity is typically satisfied when a witness states that a document is what it purports to be, the actual requirements for the rule are far more complicated than that. That the proponent must provide sufficient evidence to support a complex, Your Honor, must provide sufficient evidence to support a finding that the item is what the proponent claims it is. As Ms. Durst is the only witness with knowledge of this exhibit, a question of its authenticity has been raised, and as an offer of proof, should Exhibit 4 be admitted, Blake Doncourt, a supposed recipient of this email, will testify to having never received it.
Mr. Cooper, if you would ask the witness, please, whether I believe that her name is on it, ask her if she received it. Let's lay a
Yes.
foundation here.
Yes, Your Honor. Did you receive this email?
Yes, it had been sent to me. So I had read it, and that is how we began to conduct the second study actually on humans.
Okay, Mr. Brennan, does that satisfy the authenticity leg of this exhibit?
Your Honor, as it relates to Carson Durst having read this exhibit, if you take note at the categories that the exhibit is labeled under, it will be seen that it is unread, and as such, it furthers the point that this email may in fact be fabricated by Carson Durst, seeing as they are the only witness with knowledge of this exhibit.
Well, based on this witness, though,
Your Honor,
not your witness, but this witness, she testified not only did she read it, but she received it. So that's what I'm asking, Mr. Brennan, her receipt of this document. Does that, notwithstanding what your witness may testify to, this witness is testifying to that. You may, of course, address that on cross-examination, but as it sits right now on her direct, do you maintain that objection?
Yes, Your Honor, seeing as Ms. Durst was the one who sent Exhibit 4 into the case problem today, you can see under the category specifically that it is marked unread, meaning that Carson Durst never in fact received this email.
Right, can I see the document again? I can't see the whole document. All right, Mr. Brennan, I see now what it says categories, unread, read category. Is that what you're talking about?
Yes, Your Honor, and before we proceed, just to clarify for the court, I am Mr. Hernandez.
Oh, Mr. Hernandez, I'm sorry. I apologize. I'm looking at the wrong list here. Well, no, I had Ms. Brennan circled as lead counsel, and that's what I was talking to. So that's my fault, Mr. Hernandez. I apologize. Now, Mr. Hernandez, you're looking at this indication here in the caption where it says categories, unread, read category.
Yes,
is that correct? What do you want? How do you want me to interpret that?
Your Honor, we suggest that this exhibit has been fabricated by Carson Durst, and as such fails to meet the qualifications of authenticity in court today.
Yeah,
Your Honor, may I respond?
Not quite yet, because you're Mr. Hernandez, you say that it's been fabricated because it says unread. Is that right?
In addition to no one having any knowledge of this exhibit. Yes, Your Honor.
Yeah, let's not deal with that one yet. you're saying it says unread, meaning no one got it? Is that what you think this means?
Yes, Your Honor. Nobody got it in specifically relating to Carson Durst not having received it, despite her testimony in court today saying that she did.
So what you're saying, this is a legend here on this email that appears under categories, which means it was part of the composition of the email, that whoever wrote this, Mr. Jerry Langley, under categories put unread. Is that what you're telling me?
No, Your Honor, that was the folder that it was in.
I'm sorry, that was what?
The folder that it was placed in as it relates to the email being received.
All right, here we go. Well,
Your Honor, may I respond to this now?
Well, hang on here. Yeah, go ahead, Mr. Cooper. I'm probably going to let Mr. Hernandez do some voir dire on this, but you may give me some input.
Okay. Your Honor, this is stipulated fact number 1, and it reads, the signatures on the witness statements and other documents are authentic, and other documents would provide testimony to the exhibits.
Well, it may be an authentic exhibit and still be, the document may be authentic. This is the one that, everybody knows is in existence. Whether anyone received it, whether it was actually sent out at the time, may be a different issue. I'll tell you what, I'm going to let Mr. Hernandez, he'll use some of his time to do this, but I'm going to let him voir dire this witness on this document on its authenticity, so I can make a decision on whether or not it's going to come in. So Mr. Hernandez, go ahead. And your time will run on this. This is not part of your objection. This is part of voir dire on a document. So your time will run on this if you wish to use it.
Your Honor, while I would love the opportunity to voir dire this exhibit, pursuant to the rules of competition, I am not allowed to do so.
Oh, okay. I wasn't aware of that. Never had. The issue's never come up. Thank you for clarifying the rule to me. With that said, because the testimony on direct is that Ms. Durst she testified she received and read this document contemporaneously with the September 18 date, and without any other information, where it says category unread, read category, I have no idea what that means. I don't know what red category means other than really important, maybe. Unread, I have no idea what that means. Why Jerry Langley would publish a memo, create a memo, and then state right on it at the time he wrote it, unread, meaning no one will read this, doesn't make a lot of sense to me, quite honestly. So I don't know. I have no answer to that question. So in the absence of that, any answer to that question, I will admit, what is this, Exhibit 4? And Mr. Cooper, you may proceed. You're going to, of course, cross Mr. Hernandez when you get this witness. Mr. Cooper, go right ahead. Sorry we took so much time on this, but that's the way it goes sometimes.
Thank you, Your Honor. What was your reaction to this email?
That there was bias and that they had wanted us to read it in a specific way.
They had, when you say they wanted to read it in a certain way, are they talking about the email?
Yes. Yes.
Did they also want you to read test results in a certain way?
Yes, it hadn't really been any unique thing of them.
Was there any concern around the results of the second study?
Yes, it had been concerned that it could cause non-Hodgkin's lymphoma, which is the cancer the patient has.
And to be clear to the jury, the second study was the one in humans, going into if it was carcinogenic in humans?
Yes, that's true.
And what did your bosses say to the finding that it could cause non-Hodgkin's lymphoma?
To keep it in the walls, and there would be further analysis that needed to be done.
And what does in the walls mean?
That they hadn't wanted to get it out to the public, and that they, until they had been completely sure of what could happen with this product, that they hadn't wanted to get out for any concerning reasons.
And was there a solution to this problem?
Yes, to bake the fertilizer.
And if you know, why does Lush not bake their products?
See, it's not a big thing, but it's, to them, it seemed like the way that it had been phased to bake the fertilizer, that it'd be going above and beyond, and that it had then too much of a good thing, and so they had not.
And did you ever see a report of findings of the second study?
I did.
And what did that report say?
It had mentioned how there was little to no risk using the fertilizer, but it had no mention of it causing cancer, which had caused a bit of curiosity there.
So the final report left out that the use of Drufo may cause cancer.
Yes.
No further questions, Your Honor.
Mr. Hernandez, cross-exam.
Yes, Your Honor. Before I begin, may I inquire as to how much time I have remaining?
I'm sorry?
May I inquire as to how much time I have remaining for my cross-examination, Your Honor?
Too fast. I can't, you were so far away from the microphone, I just can't hear you. Let me put you on the other view here just a minute. This is my fault.
He had been asking how much time he had left for his.
A time check. I'm sorry. The context, I just wasn't connecting.
Yeah.
Absolutely, you can get a time check.
You have 15 minutes and 47 seconds remaining.
Thank you.
Thank you, Your Honor. With that, I'm ready to proceed.
Go right ahead.
Ms. Durst, on direct examination, you testified to being the lead product developer at Lush Fertilizer, correct?
Yes.
Have you ever said, I was promoted to a full-time position as a product development engineer?
Yes, I was a product engineer.
And nowhere in the rest of your statement do you say that you were promoted to anything beyond that, correct?
No.
So you were fired from Lush in December of 2006, correct?
Yes, that is true.
You haven't worked at the company since then?
No, I have not.
You are now the lead product developer at Terrace Greenery, right?
Yes, that is true.
You have been working at this company for more than 15 years now?
Yes.
And Terrace Greenery is a direct competitor of Lush Fertilizer, isn't it?
Well, yes, it is. It is.
When you joined Lush Fertilizer, you joined as an intern in June of 2003, right?
Yes, that is true.
You were brought on to the Drufo team?
The Drufo team? I had been brought on to the research and development team. And
Misters, you conducted research on Drufo when you were brought on the research and development team as an intern, correct?
yeah. What? I had done my internship as a research and development engineer, and I had been roughly 3 months after starting my internship, I had gotten the job, and that's when I had started doing the study into Drufo.
Misters, that wasn't my question. When you joined Lush Fertilizer as an intern, you were placed on the research and development team.
Yes.
That was studying Drufo, correct?
I don't think I'm understanding your question.
Your Honor, if I could have a moment, it appears that we are experiencing technical difficulties.
Okay, I understood the question. Why don't you go ahead and just ask it a different way? Maybe that'll have some understanding then. Just ask the same question a little different way. Rephrase.
Your Honor, while I understand that the witness understood my question, our camera has been taken down and we would just request a moment to fix that issue.
Oh, your camera on your end. Okay, yeah, absolutely, sure.
Yes, Your Honor, thank you.
Yeah, we'll stop the time at this moment. I'm sorry.
Your Honor, can you see and hear me?
Yes, can.
All right, perfect. So, misters, have you ever said that when you were brought on to the research and development team, you were placed on the DRUFA team?
On the DRUFA team?
Yes or no?
I'm not sure if there was a DRUFA team. I just know that I was with where I have been, that we had been working on DRUFA since it was in its testing stages.
Well, misters, when you joined the DRUFA team, the company was in the middle of researching and testing the safety of the product, correct?
Yes, I did just say that.
And there were engineers and scientists involved in that research and testing?
Yes.
The company had procedures in place to monitor their ongoing studies, right?
I'm so sorry. My computer is about to die, so you cut out. Can I deal with that for a second?
Yes, you may. We'll stop time. Thank you.
I'm so sorry. Thank you.
No, it's all right. It's all right. Happens on both sides. Not a problem.
Your Honor, may I return to council table as we wait for opposing counsel?
Of course.
Yes, Your Honor.
So sorry for the inconvenience. I should be ready now. So sorry.
Okay, and hang on for just a moment and we'll have Mr. Hernandez back shortly.
Yes.
Yes, Your Honor.
Okay. Mr. Hernandez, we'll start time again. Go right ahead.
So, misters, yes or no, Lush Fertilizer had procedures in place to monitor their ongoing studies?
Yes.
Now, let's focus on the studies that you mentioned on direct examination. I'd like you to pull up Exhibit 3 there in front of you.
Yes.
Do you have it?
It's on the screen.
Yep. And Exhibit 3 is admitted. You may proceed.
Yes, Your Honor. This is the study you found from England?
Yes, it is.
This study was not conducted on humans.
It wasn't, but it did have mention of humans in the last paragraph of the conclusion section.
Misters, this study was conducted on rats, correct?
Yes, it was.
And if I could have my trial technician highlight the first two paragraphs of the second column, the methods column. Misters, right here it says that C3N09P was fed to rats, correct?
Yes.
And the rats developed cancer only after they were fed this chemical compound, right?
Well, yes.
And you weren't going to feed Lush Fertilizer to people, were you?
No.
Thank you. My trial technician can take that down now. During direct examination, you also mentioned a second study in which certain concerns arose. However, you did receive a copy of the study report, correct?
The study, as in the email?
As it pertains to the second study, misters, you received a copy of the study report, right?
Is the question that she did or did not receive it?
She did receive it, Your Honor.
Did receive it. Okay, so that's the question, Ms. Durst.
Okay, then yes.
And the report had a statistical analysis about the effects of DRUFO, right?
The rats are humans.
Misters, have you ever said that the second study, the effects of Drupa conducted on the study report had a statistical analysis about the effects of Drupa?
Sorry, I didn't hear half of what you said.
Mr. Hernandez, we can't hear you when you're that far away and not facing the microphone.
Yes, Your Honor.
So let's grab whatever you need to grab and come on back. There we go.
Thank you.
So, Misters, have you ever said, a month or so later, a copy of the study report hit my desk,
Yes.
and this study report had a statistical analysis about the effects of Drupa, correct?
Yes.
And we can agree there are certain legal requirements that Drupa had to meet in order to be sold.
Yes, there was.
This study demonstrated Drupa was within those legal requirements, right?
Yes.
And the study went as far as to say that baking Drupa would not be necessary because it already met those legal requirements.
But it also did mention how baking Drupa would cancel all risk of there being a carcinogen in their product.
But Mr. Yes or no, the study demonstrated baking Drupa would not be necessary because it already met the legal requirements.
Yes.
And this study also recommended further research be conducted.
Yes.
However, you couldn't do your job well enough to be involved in any of those future studies.
Objection, Your Honor, speculation.
Could you state the question again, please?
Yes, Your Honor. Misters, you couldn't do your job well enough to be involved in any of the future studies.
Okay, I understand the question. And why is that, Mr. Hernandez, why is that not speculation? That's the objection.
Your Honor, given that I'm asking the witness to testify about their own perceptions and observations about their job performance, this is not speculation pursuant to Rule 701.
Mr. Cooper?
Your Honor, I believe that she is testifying on, or that opposing counsel is asking her to testify on the reason that she was fired, even though there's no way that she could have known that.
Well, we're talking about, my understanding of the question has to do with the report. Is that correct, Mr. Hernandez? And further testing.
This is specifically relating to further testing in addition to Mr. job performance.
Your Honor, as she was no longer with the company, she cannot testify to what Lesh did or did not do as opposing counsel is asking her to.
You'll have to lay some foundation for that, Mr. Hernandez, about whether she was able to do the testing, whether she was around to do the testing, whether she was on the team. If not, then she had no way to do testing. If she was, well, maybe she has an answer for it. So you may lay foundation if you wish to ask that question.
Yes, Your Honor. So, Misters, immediately following the second study, you were told that this company would be conducting further research, correct?
Yes.
However, you never heard of any further testing while you were at Lush Fertilizer, right?
Well, no.
And this was because your job performance was rapidly declining. Isn't that right?
Well, I don't think my job performance, or what was it that you said? My job what?
Your job performance, Misters,
yes,
was rapidly declining, correct?
I don't think it was. I just know that I had been put on a performance improvement plan because I had just.
Misters, you were failing your job performance reviews, correct?
What? May you repeat that?
Mr. Hernandez, do we have you? Looks like your screen is frozen to me.
Yeah, I wasn't sure if that was just my screen.
No, I think we're having a connection problem here. They're trying to reconnect.
All right.
Your Honor, can you hear us?
Oh, there we go. And Mr. Hernandez, do we have you again? I think I see you on screen. It's a different view of you. Looks like it might be the witness camera. It is the witness camera. And you're muted on the witness camera. I can see you, but you are muted on that camera. If you can hear me. Boy, that one's frozen now too.
Oh gosh.
Oh. As they say, stuff happens. Do I have the scoring panelist for the defense? I'm not scoring panel, the timekeeper for the defense?
Yes, Your Honor.
Are you in the same room with those folks?
I am not, Your Honor.
Oh, too bad. It looks like both of their cameras have frozen up. Both
Yes,
the-
Your Honor. Our internet connection seems to be a bit unstable right now.
Okay, well, we'll wait.
Thank you, Your Honor.
Fortunately, this is the second trial, so Bar Association won't like it, but we'll take as much time as we need.
Thank you, Your Honor.
Your Honor, can you hear us now?
I can hear you, yes. Can't see you though yet. Now it looks like you may be trying. I've got the attorney camera without a picture, but I've got it on my screen. It is also muted. Now I have a picture, attorney camera, video, and I should have sound.
How's that looking, Your Honor?
Good.
Perfect. You're able to see and hear me all right?
Yep, and if you'd, I'll tell you what, if you'd, can you adjust the angle of your attorney camera?
Your Honor, we are still unable to change the setup that we currently have.
Not in or out, just up or down?
Same challenges apply, Your Honor.
Same thing. Okay, that's not a problem. Yeah, if you came any closer, it would cut your head off, so that's all right. Okay, now, do you remember, Mr. Hernandez, where you were?
Yes, Your Honor.
Let's have a question and we'll start our time again.
So, Mr. As we were just talking about your job performance, you received poor scores on your annual performance reviews?
Yes, I did.
There were mounting complaints from your coworkers and staff.
Yes, there had been.
And you currently work at Terrace Greenery, correct?
Yes, I do.
Objection asked and answered.
Asked and answered, but not in direct, but not in cross. You may continue.
Yes, Your Honor. Ms. Durst, if Lush Fertilizer is found liable today, your company will likely overtake Lush Fertilizer in the market. Yes or no?
I'm not going to confine her on that question to a yes or no question because it may be, or a yes or no answer, because it may be take more of an answer than that. Some questions are permitted yes or no, not that one. So you may answer as you will, Ms. Durst.
All right. Could you repeat the question then?
Of course, Ms. Durst. If your company is a direct competitor of Lush Fertilizer. If they are found liable today, yours will likely overtake them in the market. Isn't that right?
Well, it could if anything happens to Lush, but that's just because we've had nothing wrong with our product and that that we've been doing well with our product and how we've been developing, and that's just our growth. And as for Lush, that would show that there is something wrong with their product and that it can cause harm. So it would definitely affect them and how they're doing. And it wouldn't exactly.
Thank you, Ms. Durst. That was a yes to my question, correct?
I was just answering it how you had been asking.
Right, and as it relates to today's trial, you haven't disclosed how much Terrace Greenery has paid you, correct?
What do you mean exactly?
To testify in court today.
Objection, Your Honor, relevance.
And the question again, Mr. Hernandez, you broke up a little bit.
Your Honor, I asked the witness if Terrace Greenery if she had disclosed how much Terrace Greenery is paying her to testify today.
Oh, to testify today. Okay. Mr. Cooper, and you said relevance?
Yes, Your Honor.
Mr. Hernandez, as to that objection?
Your Honor, if Ms. Durst has a financial bias in today's case and trial, it is extremely relevant to disclose that to the jury pursuant to Rule 401.
I agree. Objections overruled. As to testimony today, you may get an answer to that question. Ms. Durst, do you understand the question?
I didn't hear the last word of his question.
One more time, Mr. Hernandez.
So sorry.
Ms. Durst, you haven't disclosed how much Terrace Greenery is paying you today to testify against Lush Fertilizer, have you?
No, I have not.
Thank you, Your Honor. I have no further questions.
Mr. Cooper, redirect.
Yes, Your Honor, I will do it.
Before we proceed, Your Honor, there seems to be a timing discrepancy referring to the defense's time remaining. Opposing counsel's timekeeper seems to have significantly less time than I do. That could just be because of the technical difficulties that we've been experiencing, but I have 5 minutes and 3 seconds left on the defense clock. What does opposing counsel have?
A defense clock for direct or cross?
For cross, Your Honor.
Okay, and you say, how much do you have?
I have 5 minutes and 3 seconds remaining.
I
And,
currently have, sorry.
No, go ahead. What do you have on cross?
I currently have 4 minutes and 19 seconds, but if we can find an agreeable time that is in between those, that is perfectly fine with me.
All right, I'm going to go with a 5:03, and part of that's probably my fault for not indicating when time would stop. We'll go with a 5:03.
Okay, if you would allow me just to set my timer to that real quick, then.
Absolutely. Yeah, just tell us when you're ready.
Thank you, Your Honor.
We'll
Okay,
all
I am
be
ready.
glad- we will all be glad next year when we're in person. So,
Yep.
Uh,
Okay, I'm ready when you are, Your Honor.
Mr. Cooper, you may proceed.
Yes, Your Honor, I will do a brief redirect. You did a study into rats, or you found a study into rats,
Yes, that is true. I did.
which then prompted a second study into humans.
Yes, it did.
And what were the results of that study?
It come back inconclusive.
And what does that mean for the jury?
Coming back conclusive means it doesn't have a direct answer or a solution to what we had been testing.
But did it have any concern around the results?
Yes, because it came back inconclusive, it had prompted concern about the product and it's causing non-Hodgkin lymphoma.
No further questions, Your Honor.
Mr. Hernandez, any recross on that issue?
Your Honor, as there is little time left for cross-examination, I have no recross at this time.
Thank you. Okay, Ms. Durst, your testimony is concluded. You are excused. Looks like we have Ms. Pavetti. You have the next witness, and we will have Bailey Burton on cross. Is that correct?
Yes, Your Honor.
Okay. And Ms. Pavetti, you may call your witness.
Your Honor, before I begin, one moment.
Whoop, little bit of an echo there.
May I inquire to my timekeeper as to how much time I have left?
Of course. Direct on plaintiff.
I currently have 7 minutes and 2 seconds on the clock.
Thank you.
Is that close enough for government work for the defense?
Yes, Your Honor.
Thank you very much. Ms. Pavetti, you may continue.
Your Honor, the plaintiff calls Dr. Casey Rogers to the screen.
Dr. Rogers, you've been sworn. Ms. Pavetti, you may continue.
Good evening, Dr. Rogers. Could you please state your name, spelling the last for the record?
Dr. Casey Rogers, Rogers.
Why are you here today?
I'm here to offer my expert testimony on behalf of the plaintiffs in this matter.
Let's talk a little bit about your educational background. What do you have your bachelor's degree in?
I've got my bachelor's degree from Colorado State University in agriculture and chemistry.
Following obtaining your bachelor's of science degree, did you continue your education?
I did. I later got my PhD in agriculture and entomology from the University of California at Berkeley.
What are your research interests?
I have many research interests, but the ones most relevant to this case are toxicology and chemicals.
Are you a medical doctor?
No, I'm a toxicologist.
What's the difference between a toxicologist and a medical doctor?
Well, to put it simply, a medical doctor's job is to treat a patient with a certain disease, while a toxicologist's job is to work backwards and figure out how a person came across a certain disease and how to prevent people from getting the same disease.
To your knowledge, has your research been used in front of advisory boards before?
Yes, it has. It's been used before litigations and advisory boards, and I've also given personal recommendations to companies and administrative bodies on what their employees can and cannot do if they come in contact with chemicals.
Have you published any scholarly articles?
I have. I've published 6.
How many involve Drufo?
4 of which involve Drufo, 1 of which involves Drufo in humans.
Your Honor, I would like the record to reflect that my co-counsel is now pulling up exhibits 6 and 7 for identification purposes.
And we have those. Go right ahead.
Dr. Rogers, what is exhibit 6?
It's my CV or resume.
How do you know?
I wrote it.
Is it true and accurate to the best of your knowledge?
It is.
Now turn your attention to exhibit 7. Have you seen this document before?
I have.
How do you know?
It's a list of all my research publications, and I wrote it.
Is this document also true and accurate to the best of your knowledge?
It is.
Your Honor, I move to enter exhibit 6 and 7 for its accuracy has been shown and authenticity stipulated to.
And I'll get myself lined up here again. Ms. Burton, any objection to 6 or 7?
Yes, Your Honor. To both 6 and 7, I object hearsay, as this is an out-of-court statement being offered to prove the truth of the matter asserted. The truth of the matter asserted of Dr. Rogers' qualifications in today's case. In addition,
I'm sorry, go ahead.
In addition, this information is needlessly cumulative pursuant to Rule 403, as Dr. Rogers has already testified about her qualifications, and entering this admission would only be to further show the jury more qualifications and her truthfulness, which is up to them to decide.
And Ms. Pavetti?
Your Honor, to the objection of hearsay, this document is an out-of-court statement, but it isn't being offered for the truth of the matter asserted for this case today. And that goes along with the cumulative objection. There are numerous things that I did not cover with Dr. Rogers that will be helpful for the jury to understand her further testimony.
And Ms. Burton, I'll give you the last word.
Yes, Your Honor. For the hearsay objection, or exception that opposing counsel mentioned, proper foundation has not been laid for this. Therefore, both of these documents are still hearsay.
All right. I'm going to overrule the objection, but only for this reason. Because of time concerns, the objection is correct. If we had time, if I did not allow these in, I would have to allow time for Dr. Rogers to go through all of this. And we just don't have that time. So only because of that, we don't have the time in this trial. I'm going to allow the jury to consider 6 and 7 as to all of the additional things that she has not already testified to. So with that said, they're in. Ms. Pavetti, go right ahead. The exhibits are in.
Your Honor, pursuant to Colorado Rule of Evidence 702, the plaintiff asked the court to accept Dr. Rogers as an expert in the fields of chemical toxicology on humans and drufotoxicity and carcinogenicity.
And what is the second area again?
Drufotoxicity and carcinogenicity.
Ooh, what's that word? That first word?
Toxicity?
No.
Drufo.
Oh, DUFO. I'm sorry.
Drufo, yes.
Of course. Specifically in DUFO. Okay. So Ms. Brennan, do you have any objection to qualifying the witness in that area with the chemical toxicity specifically involving DUFO?
Your Honor, just before I begin, my last name is Burton for the record.
I'm sorry, once again. Hold on, let me get you up in off gallery here. Now I can see you. I can go ahead.
Yes, Your Honor, just for scoring purposes, the last name is Burton, not Brennan.
You have to slow down or come closer, one of the two.
Your Honor, opposing counsel is just saying that her last name is Burton and you accidentally called her.
Did I say Brennan? Oh, okay, my fault. Oh, I'm looking at the wrong list here again. It is Ms. Burton. I apologize, Ms. Burton, just as I did to Mr. Hernandez. Not having you in person in the courtroom makes this very difficult
Yes.
for all of you. So me included. So Ms. Burton, do you have an objection?
As for the qualifications, I have no objection to the toxicology or the emphasis on DRUFO. However, I would like to limit Dr. Rogers' testimony to prevent her from rendering an expert opinion on a medical diagnosis, medical treatment, or causes of medical conditions. As she has no medical education and has testified to no medical experience, this would be improper expert testimony pursuant to Rule 702.
All right, what the witness testified was that she does not have expertise in medical diagnosis or treatment, but that there is an interface between chemical toxicity causing diseases where there is a disease. Is it caused by this?
Your Honor,
that is different than a medical. So that's what she testified to. Ms. Pavetti, what's your position here?
Your Honor, I am also entering her as a toxicologist where she will not make any sort of medical testimony. However, she will be able to make testimony regarding on how someone got an illness, where like she works backwards. The doctor makes the diagnosis, a toxicologist works backwards from the diagnosis to how a person has received the diagnosis.
I believe you've said more eloquently what I just said. So
okay, my apologies, Your Honor.
That's my position, and I will allow the objections overruled. I will allow this witness to be qualified in the area of chemical toxicity, specifically involving DUFO, which is what we're testifying to here today. So you may proceed.
Just before you, I'm sorry, so sorry to butt in. This is Amber, the courtroom monitor. I just want to let you know that we have at least one scoring panelist, and I'm afraid that there might be more that are going to have other obligations at 7 o'clock, and we are really pushing time. So I know that there have been some technical issues and a lot of back and forth between counsel. So I just want to let you know that we don't want to have any issues with losing any more scoring panelists. So if we can just make sure that we are objecting and making sure that we're, keeping track of our volunteers' times too.
I will do so. That's entirely my fault and my responsibility, not the participant. So, understood.
Thanks so
Alrighty.
much, Your Honor.
Your Honor, before we continue, it seems that time was running during my objection. Pursuant to the rules of competition, time is stopped for an objection, and as my time has gone down to 4 minutes.
And that's correct. Time does not run during the objections. So, Ms. Pavetti, you may continue.
Dr. Rogers, let's talk about the study you conducted on Drufo. How did you arrange this study?
Well, I arranged study in 3 different groups. The first was a control group full of people who never came in contact with Drufo. The second was a group of people who came in contact with Drufo only on occasion. And the last group of people who came in contact with Drufo on a regular basis.
What did your study find?
Study lasted several years, and it found that people who were exposed to Drufo on a regular basis were 10 times more likely than those to develop adverse health effects than those in the control group, and those in the group who were exposed to Drufo on occasion were 5 times more likely than those in the control group to develop adverse health effects.
Were there any forms of cancer found as a result in your study?
There were the endocrine and endocrine varieties showed up in my study, the latter of which includes non-Hodgkin's lymphoma.
Is there anything that can be done to mitigate the risks of Drufo?
Of course, you must understand that the risks of Drufo involve breathing it in as aerosol or absorbing it through the skin. So one must wear long sleeves, long pants, and a mask to prevent exposure.
Did you review Dakota Weirs' medical records and employment records?
I did.
What did you find when analyzing these records?
Well, Dakota Weirs worked at Haven Landscaping for a period of 4 years and was exposed to Drufo regularly. This means her condition is similar to those in my study who were exposed to Drufo on a regular basis, which means I can say with a high degree of certainty that Dakota Weirs did indeed develop non-Hodgkin's lymphoma because of her exposure to Drufo.
No further questions, Your Honor.
Thank you. And Ms. Burton, cross-exam.
Yes, Your Honor.
Correct.
May I proceed?
Yes, you may.
Now, Dr. Rogers, as a toxicologist, you reviewed many different chemicals, correct?
I have reviewed many different chemicals, but Drufo caught my attention when it first came on the market back in 2003.
Yes. Now, when making conclusions about chemicals in general, you review all relevant information, correct?
I try to.
And you just specifically mentioned Drufo. Now, with Drufo, you claim it was rushed into the market without sufficient safety studies. Isn't that right?
Yes, I did just claim that because the study done by Lush Fertilizer I felt was rushed because they were trying to rush to get onto the product, get on market as soon as possible, because which allows them to sell it quicker, which means increases their profit margins. Because of that, I felt it was rushed.
Yes.
Hang on, Ms. Burton. Ms. Burton, please don't interrupt the witness. Please finish your testimony, Dr. Rogers. If I find that it is out of bounds, I will stop you.
Okay. So because of that, I felt it was rushed on the market. So yes.
However, before making this conclusion, it was rushed into the market. You never reviewed any of Lush Fertilizer's in-house studies, correct?
I was aware of their studies.
But you never reviewed them, yes or no?
Well, I was aware of their studies, and I was also aware that they didn't put enough time into their studies.
So Dr. Rogers, that's a yes to my question. You never specifically reviewed the data from Lush Fertilizer.
Specifically, I did not go over it with fine tooth and comb, but I do still believe that it was rushed onto the market because they did not allow nearly enough time to sufficiently study the data.
Now, in today's case, before making your conclusions, you reviewed Dakota's medical records, correct?
Yes, I reviewed her medical records and her employment records and have indeed confirmed that she was diagnosed with non-Hodgkin's lymphoma.
Yes, and from those employment records, you were aware that she worked with countless other chemicals at Haven's Landscaping, correct?
Yes, many people who work in that field do, but again, Drufo is special because of the effect it can have. Because the study I did, it shows that people who were exposed to Drufo are more likely to develop adverse health effects, such as non-Hodgkin's lymphoma, which the plaintiff has indeed developed today.
However, before making your conclusions, you never even requested a list of these other chemicals, yes?
I'm sorry, which do you referring to?
The other chemicals Dakota worked with, you never reviewed, correct?
I looked over her employment records and her medical records.
But you never specifically looked into the other chemicals she worked with, isn't that right?
I looked over the chemicals she worked with, including lush fertilizer.
Now, Dr. Rogers, that's a pretty important piece of information, but nowhere in your affidavit do you ever mention reviewing other chemicals than lush fertilizer, correct?
Well, my witness statement mostly focuses on my study that I did on Drufo, which is pretty important to the case because it's relevant to the case matter. Because I'm focused on studying Drufo and its adverse health effects, which means more inclined to show up with this case today because Dakota Weirs did indeed develop non-Hodgkin's lymphoma, and she was indeed exposed to Drufo for a numerous amount of time.
So that's a yes to my question. You never mentioned any other chemicals Dakota worked with, yes?
In my witness statement.
Objection, Your Honor, asked and answered.
I'm not sure it was answered, but Dr. Rogers, based on the fact it's been asked twice, I will require a yes or no answer to that.
Okay, I did not mention the other chemicals in my witness statement. I was supposed to focus on Drufo.
Now, Dr. Yes, sir. Now, Dr. Rogers, going to the chemical you do claim to cause Dakota's cancer. This chemical, the packaging of this chemical recommended users wear protective clothing, correct?
It recommended users wear protective clothing, yes, have recommendation.
However, Dakota was exposed to Drufo without use of any protective gear. Isn't that right?
I believe she said that it was hot outside and that it was not enforced at the company she worked at, therefore she did not feel the need to.
So that's a yes to my question. She misused the product by not following the safety recommendations, correct?
Well, it was a recommendation.
And she didn't follow it, yes or no?
No, she did not follow the recommendation.
Thank you, Your Honor. I have no further questions.
Ms. Pavetti, any redirect?
Yes, Your Honor. Dr. Rogers, is a recommendation the same as a requirement?
Of course not. A recommendation is just there to it's just recommending people follow it, while a requirement enforces it.
Did Dakota Weirs testify to any sort of requirement of PPE?
No, she did not.
Dr. Rogers, why didn't you review any other sort of chemicals?
I didn't review them because they were not relevant to Dakota Weirs' exposure to Drufo.
No further questions, Your Honor. And at this time, the plaintiffs rest.
Ms. Burton, any recross given the time you have?
Can I get a specific time check before I decide, Your Honor?
Of course.
You have 40 seconds remaining.
With that, Your Honor, very briefly. Now, Dr. Rogers, yes or no, even you yourself recommend wearing protective clothing when working with Drufo?
I have given numerous safety recommendations about all sorts of chemicals. I have said that you should wear, I have recommended that you should wear long sleeve and long pants when doing this, not just Drufo, but for other chemicals as well. But again, that's just a recommendation, not a requirement.
Thank you, Your Honor. I have no further questions.
Thank you, Dr. Rogers. You are excused. The plaintiff has rested. We'll now have the first witness for the defense. And who will be on direct exam?
That'll be me, Your Honor, Angel Hernandez again.
Mr. Hernandez. Okay, and we will have, give me just a moment here, try to move along. Any time issues that we have are my responsibility. So not any of your fault. We'll have Dr. Williams will be the first witness for the defense, and Dr. Williams, Ms. Pavetti will have cross, correct?
Yes, Your Honor.
Okay, Mr. Hernandez, you may call your witness.
Yes, Your Honor. We call Dr. Williams to the stand.
Oof.
Good evening. Could you please introduce yourself to the jury?
Good evening. My name is Dr. Devin Williams. I lead the Toxicology Research and Development Labs at Lush Fertilizer Incorporated, and I'm also the chair of the Ethics Committee.
And could you explain exactly what toxicology is?
Your Honor, if I may interrupt, I'm having a hard time understanding the witness and I also am unable to see her.
Yeah, I'm having she's being picked up on 2 microphones, it looks like. So, Mr. Hernandez, when your witness is talking, we still have your microphone and your camera. Can
Your
you,
Honor,
I'm sorry?
due to our setup, we are only allowed to use 1 microphone. Otherwise, we will have a feedback situation on our hands.
Oh, I see. But okay, so we're not getting any feed on the witness camera for some reason. At least I'm not getting any.
Yes, Your Honor. If we could have a moment to fix the situation.
Yes, you may. Yeah, let's move forward. We're under some time pressure. That's my fault. So we need to move forward. All right, I've got the witness camera up now.
How's that, Your Honor?
Looks like it's working. All right, let's go ahead then.
As we were discussing, could you explain what toxicology is?
Of course. Toxicology is the study of how environmental factors affect both the human body and the environment. I research and evaluate test results to see if a chemical or compound might cause harm and how to mitigate that risk if harm is caused.
Did you receive any education in this field?
Of course. I earned my master's degree in forensic toxicology, my PhD in pharmacology and toxicology, both from Colorado State University, as well as I completed a specialized post-PhD program in pharmacotoxicology at the University of Utah.
Now, Dr. Williams, I'd like you to have Exhibit 9 there in front of you. And if my trial technician can allow Exhibit 9 for purposes of identification, Your Honor.
Yes.
Dr. Williams, what is this exhibit?
This is my curriculum vitae. It's really just a fancy word for resume. It includes all of my education, work experience, certifications, and publications.
I'll tell you what, let's try to short circuit this CV. I let the other one in. Are you going to have any objection to this? Let's see, who have I got on cross here? Ms. Pavetti?
No, Your Honor.
Let's bring him in.
Yes, Your Honor.
Go right ahead. You may testify.
May I publish to the jury?
Yes, you may.
Now, Dr. Williams, could you tell us exactly what this exhibit shows to the jury?
Well, I can't go through everything, but the highlights, you can see the 4 courses I teach in toxicology at the University of New Mexico, my certifications in clinical and forensic toxicology, as well as my—
Objection, Your Honor, cumulative.
If we have the document in, any further testimony is cumulative. You may, with the CV in, you may offer this witness.
Well, then at this time, Your Honor, I ask that the court recognize Dr. Williams as an expert in the field of toxicology.
Toxicology generally.
Yes, Your Honor.
Ms. Pavetti, any objection?
A brief voir dire.
Very brief.
Yes, Your Honor. Dr. Williams, when you joined Lush, half of the original Drufo team had already moved on.
That was the case, yes.
And you started as a technician, not a toxicologist.
As is standard in the field, yes.
You mainly oversee environmental impacts.
That's my primary focus. However, I also oversee testing on the safety of Drufo.
But mostly environmental does not mean mostly human, correct?
No, as I said, my focus is mostly on the environmental impacts of Drufo, given that safety has already been tested and retested.
And just to be clear, you work for the defendant company, Lush Fertilizer.
That's correct.
So you are not an independent expert.
I guess that could be said. However, my employment has not affected my testimony today.
Your Honor, we have no objections with this witness being entered in as a toxicologist. However, we do ask that she make very limited testimony on human impacts because she did admit to only mainly overseeing environmental.
The court will admit this witness as an expert in toxicology. The jury can weigh the weight of her testimony based on what they've heard as far as her qualifications, but not the qualification to testify. So, Mr. Hernandez, you may continue.
Yes, Your Honor. And if my trial technician can pull up Exhibit 9 again so that the jury may reference Dr. Williams' qualifications.
Yes, you may.
Dr. Williams, have you worked as anything other than at Lush Fertilizer?
Yes. Notably, I spent time at helping the medical examiner determining how.
Objection, Your Honor. I'm going to renew my previous objection of cumulative as this is just wasting time. The jury is able to read her prior qualifications, and I'm assuming that you did enter her as the expert in toxicology.
Yes, but not unless they are directed to specific things. I qualified this witness, not the jury. So I looked at this and qualified the witness. Mr. Hernandez, you may continue.
Yes, Your Honor. Dr. Williams, would you like to finish your response?
Yes. As I was saying, there I worked on determining cause of death and how specifically drugs and other environmental factors could have led to death.
Thank you, my trial technician can take that down now. Now, as it relates to your job at Lush Fertilizer, what exactly did your job there entail?
I oversee work on all environmental impacts and safety testing of Lush Fertilizer products, specifically Drufo.
And what is Drufo?
Drufo is a patented binding agent. What it does is it glues the fertilizer components both to themselves and to the plants that it's sprayed on, meaning that less fertilizer has to be used in the long run and is therefore safer for both the environment and people.
Did Lush Fertilizer ever test this product?
Of course, we've done extensive testing on both safety and environmental impacts, making sure to do follow-up testing for any concerns that arose.
And did the company use any specific process to test the product?
Yes, we use what's called correlational studies, where we take two or more very similar groups of people and look at the occurrence of certain factors.
Could you provide us with an example?
Yes, so in context of Drufo safety testing as it related to cancer risks, we looked at two groups of farm laborers, one who used exclusively Drufo-based fertilizers and the other which used exclusively other fertilizers, and looked at how many people in each group were diagnosed with cancer.
And how do you know that the differences between these two groups isn't caused by something else entirely?
That's why we use very similar groups. We try to eliminate what's called confounding variables, the differences between groups that could also account for the difference, in this case, in the rates of cancer. Things such as diet, exercise, sun exposure, really anything.
So then, can you rely on every possible variable?
There are some variables that are just so extremely unlikely that they're difficult to account for, such as the use of our product by a minor or the blatant misuse of our product.
Now, Dr. Williams, have you been made aware of Dr. Rogers' study?
Yes, I have reviewed it, and I have to say, as a fellow researcher, it's extremely concerning.
How so?
Going back to the confounding variables I mentioned, there are so many differences between the groups Dr. Rogers used. She compared farm laborers to hobby gardeners to run-of-the-mill people. The number of environmental differences between those groups is astounding, any one of which could have contributed to anyone's risk of being diagnosed with non-Hodgkin's lymphoma.
And aside from those differing study groups, did you have any other concerns with Dr. Rogers' study?
Yes, the study itself was also never replicated, which is the process when another independent scientist reviews the data and reconducts the study to make sure that it's accurate.
Now, Dr. Williams, in your expert opinion, can Dr. Rogers' study be trusted?
No, with the lack of replication, meaning the lack of affirmation that it's accurate, it could very well be a one-off fluke or simply the result of bias. The truth is, Drufo has not been linked to a higher risk of non-Hodgkin's lymphoma.
In your expert opinion, was this study misguided?
Absolutely. The differences in study groups make it virtually impossible to come to a valid conclusion.
And would you say that it's misinformed?
Yes. Even if the study was done correctly, there's no way Dr. Rogers could have determined causation. It's simply not possible.
And throughout the trial, we've heard of Dakota Weirs' misuse of countless fertilizers. How does that affect your conclusions?
Any one of those fertilizers could have contributed to Ms. Weirs' risk of being diagnosed with non-Hodgkin's lymphoma. As unfortunate as it is, Drufo is not one of those risk factors.
Thank you, Your Honor. I have no further questions.
Ms. Pavetti, cross-exam.
Yes, Your Honor. Dr. Williams, you believe Drufo to be revolutionary?
It's not just my belief, it's true.
And that's because it acts as a bonding agent for both the fertilizer itself and for the fertilizer in the plant it's attaching to?
Yes, that's correct.
Because this is supposed to eliminate the amount of nitrates released into nature.
Yes, excess nitrates are a huge problem.
And that is why the European Union has decided to ban Drufo?
Yes, temporarily at least. We're in the process of overturning that decision.
But Drufo does not actually eliminate nitrates from being released in the fertilizer, does it?
We can't ever truly eliminate entirely the nitrogen in the soil. However, it vastly reduces it.
It actually just reduces the amount of fertilizer being used, correct?
Yes, and all fertilizer includes synthetic nitrogen, which can leach into soil. So by using less fertilizer, we use less nitrogen.
You've made numerous criticisms on Dr. Rogers' study, correct?
Yes, because it's incredibly misguided.
You criticize her on not having her study peer-reviewed?
That's correct.
Also on not having limited the sample groups to only groups of laborers?
Absolutely.
You also criticize for it not having been replicated.
Yes, as I said on direct.
But would you agree with me that all of these criticisms mainly just go against the scientific method?
No, all of those criticisms are based in the scientific method.
My apologies. All these criticisms are based solely upon the scientific method, correct?
Yes, as the method that we use to conduct research and make sure that it is accurate.
You also criticize in your affidavit Dr. Rogers for having a financial bias.
Yes, I understand that Dr. Rogers hopes to be part of more of such lawsuits.
You've worked at Lush for 10 years, correct?
Going on 12 now, actually.
My apologies. Your career has also grown significantly since starting.
I wouldn't say that, no.
Well, I mean, you are now the lead of the R&D labs, are you not?
Yes, as is standard for the amount of experience I have in the field.
You went from technician to the head of the R&D labs, correct?
That's correct.
So it's fair to say that Lush has been very good to you?
They recognize my skill and experience, yes.
But having had that major promotion, that includes financially, correct?
I do make more money now. However, it has not affected my testimony today.
However, you are also being paid by Lush extra to be an expert witness for their side, correct?
Yes, but my first priority is to seek the truth.
No further questions, Your Honor.
Mr. Hernandez, redirect.
Briefly, Your Honor.
I'm going to hold you to that, Mr. Hernandez.
Of course.
If you say brief, then be brief.
Yes, Your Honor. Dr. Williams, how do you account for the differences between the European Union's branded fertilizer and the United States?
There is a ban on any new fertilizer compounds which are shown in lab settings to increase nitrates in the soil, which of course is impossible to avoid. However, we are in the process of overturning that decision given our recent research that it does reduce nitrates in real world conditions.
And how serious was Lush fertilizer in testing Truffaut?
We hold ourselves to the highest safety standards.
And has your financial bias affected your testimony in court today at all?
No, first and foremost, I'm a truth seeker. I conduct research to make sure that I am spreading accurate information to the public.
Thank you, Your Honor. I have no further questions.
Ms. Pavetti, recross.
No, Your Honor.
Thank you. Dr. Williams, your testimony is concluded. You are excused. Next witness for the defendant is this Mr. or Ms. Burton. Is this your witness?
Yes, Your Honor.
And we'll have, let's see, this is Skylar. Mr. Cooper is doing cross, correct?
Your Honor.
Ms. Burton, you may call your witness.
Your Honor, the defense calls Skylar Weirs to the stand.
And you may proceed.
Yes, Your Honor. Good evening. Please introduce yourself to the jury.
Good evening. My name is Skylar Weirs. I'm an investigative journalist for The Rationalist. I'm also Dakota Weir's twin brother.
Now, Mr. Weirs, during your testimony today, we're going to partly focus on your time as an investigative journalist, but also your relationship with your sister. Now, to begin, let's start on your work. How did you become an investigative journalist?
Well, ever since I was young, I've always been fascinated with agriculture and technology, the process we call today modern agritech. Originally, I wrote about this as a hobby, but eventually my work was picked up by a magazine called The Rationalist.
And what exactly is The Rationalist?
The Rationalist is a scientific magazine that seeks the truth, despite the controversies it may create. In order to be part of this mission, I've sacrificed a lot.
Now, Mr. Weirs, when working at The Rationalist, what types of articles have you researched and published?
Well, originally, I wrote a series on the conflicts between individual health and corporate policy. But more recently, I wrote an entire series on modern agritech.
And when writing that series on modern agritech, what types of articles did you reference?
Well, I try to make sure that everything that I give to my readers is as accurate and as truthful as possible. So I reference any information that I can find from companies, studies done by those companies, as well as independent studies. And then I'll cross-reference those studies to make sure they're reliable.
And did you ever specifically review Lush fertilizer and its compound Drufo?
Yes, I did. Actually, it was one of the first articles that was published.
And when researching that specific chemical, did you rely upon any other sources of information?
Yes, for Lush fertilizer and every fertilizer I researched, I reference tons of information from the USDA and NASDA as they're the most reliable.
Your Honor, at this time, I move to tender Skylar Weirs as an expert in modern agriculture. Pursuant to your pretrial ruling in today's case, sufficient evidence needed to be laid that Mr. Weirs had cross-referenced articles, released articles, and had referenced articles in the agritech field, as well as gotten information from the USDA and NSDA. As we have laid foundation to all of this, it has met the pretrial qualifications.
And I am aware of the pretrial ruling, Mr. Cooper. Based on that, any objection to qualifying this witness?
Voir dire, Your Honor.
On what issue? Based on my pretrial ruling?
As you will see, we are actually going to establish that the witness has a pre-existing bias and will object to Skylar Weirs being entered as an expert.
You may explore any bias on cross-examination. I will qualify the expert based on my pretrial ruling as to his qualification as opposed to his credibility. Ms. Brennan, you may proceed.
Yes, Your Honor.
I'm sorry, it's not Ms. Brennan, it's who have I got here?
Burton, Your Honor.
Ms. Burton, sorry.
No problem. Now, Mr. Weirs, going back to today's case, now that you've been admitted as an expert, what exactly is modern agritech?
Oh, well, in short, modern agritech is the processes, the technologies, and the effects of all modern agricultural products.
And when researching modern agritech, have you looked into many different chemicals?
Yes, each article that I wrote was focused on a particular chemical, company, or combination of the two.
Now, when going to Lush fertilizer specifically, did you find anything about health risks?
Most chemicals come to our concern because a concern has been raised about their health risks. In the case of Lush fertilizer, however, all of these concerns had no actual research to back it up.
So were these concerns basically raised as pseudoscience?
Yes, which is something the rationalist tries to combat.
So from your research, how did Lush fertilizer specifically reduce risks?
Lush fertilizer reduces the risks of its product in two very important ways. The first is that by containing Drufo, Lush fertilizer needs significantly less nitrogen than all other fertilizers on the market, making it safer. And second, by Drufo being an effective bonding agent, Lush only needs to be applied twice a year versus other companies 5 to 6 times.
Okay, now that we've talked about your time as an investigative journalist, I want to move on to a little bit of your relationship with your sister. Now, the jury sees today that you're on different sides of the case. Why are you testifying?
Well, many people think that I'm here to testify out of spite or for the inheritance, but really, that couldn't be further from the truth. I love my sister, and if she was blaming the right chemical, I wouldn't hesitate to be her leading supporter.
Now, Mr. Weirs, today we've heard about your sister's work at Haven's Landscaping. As her brother, before today's trial, did you have a general knowledge of what this work entailed?
Dakota worked at Haven Landscaping for many years, And since we lived together, I got a pretty good understanding of what she did and what company policy was like there.
Now, only based on your interactions and knowledge of your sister's work, did she work with many different chemicals?
Yes, Dakota was a landscaper, meaning he sprayed many different chemicals, some very harmful, on a daily basis.
Objection, Your Honor. This is outside the scope of the witness as he is testifying on Dakota's behalf and Skylar Weirs is not Dakota. And Dakota has already testified.
Well, and the witness just said he was aware of her job. Overruled. You may continue, Ms. Burton.
Yes, Your Honor. Did you get a chance to finish your answer?
In brief, I'll sum it up. Dakota worked with many dangerous chemicals on a daily basis.
And based on your own research of modern agritech and your knowledge of your sister's work, why are many chemicals dangerous in the agritech field?
Many chemicals are dangerous because of the amount of synthetic nitrogen, a known carcinogen, that they contain.
Now, I want to talk about the chemical at issue in today's case. I'd like to direct your attention to Exhibit 1, which should be in front of you. Your Honor, permission for my trial technician to also show to the jury.
Yes.
Now, I just want to break down this exhibit a little. At the top, it says hazards. How is this significant?
One of the very key hazards.
Objection, Your Honor. Cumulative. Also, due to time, the jury can read, and reading aloud the exhibit is just a waste of time.
Ms. Burton, let's zero in on what you want this witness to testify to, please.
Yes, Your Honor. Going a little before the hazards, I'll have my trial technician highlight this section, keep out of reach of children. Now, Mr. Weirs, how old was your brother when he started working at Haven's Landscaping?
My sister started working at only 14, just a child at the time.
And going over to the active ingredients, the second chemical is nitrogen. Now, you were just talking about nitrogen. What role does this play?
Nitrogen is a known carcinogen. In lush fertilizer, this is substantially reduced by druthol, which prevents it from interacting with the user. But in other chemicals, this nitrogen is the main ingredient and is often exposed to the person who uses it.
Now, lastly, going over to the user safety recommendations. First, it says to utilize protective clothing when working with the product. Based on your knowledge of your sister's work, did she wear protective clothing?
Based on what I heard, Haven Landscaping never taught her to wear protective gear, so she didn't wear any.
And did she wear an N95 face mask?
Again, Haven Landscaping never trained her to, so she didn't.
Okay, thank you. Exhibit 1 can be taken down. Now, Mr. Weirs, based on your knowledge of modern agritech, is this general misuse of a product concerning?
Yes, but not for the reason you think. It's true that Dakota misused Lush fertilizer, but Lush is safe. The problem becomes that Dakota misused every other product she worked with, which is significantly more dangerous.
And why are these chemicals known to be more dangerous?
Again, these chemicals contain a significant amount of synthetic nitrogen, which is known to cause cancers.
Okay, so we've talked about the misinformation around Lush fertilizer, and we've talked about how your sister misused Lush fertilizer. Now, in the end, are these actions misguided?
Yes, extremely. Dakota should never be blaming Lush because Lush is safe. Haven Landscaping never trained her to wear protective gear. Because of that, she didn't know how to work with chemicals properly.
Thank you, Your Honor. I have no further questions at this time.
Mr. Cooper, cross-exam.
I will try to make it brief due to time, Your Honor, but yes.
You may proceed.
You have no college degree, correct?
I chose to pursue my career.
meaning you have no formal training or education besides a high school diploma, correct?
Yes.
And so you have no formal training about agricultural technology.
I do not have a degree in it, no.
And you didn't or haven't worked with DRUFO or any possibly carcinogenic chemicals in a lab?
I have not.
And your research into DRUFO only lasted a year.
Countless hours, counsel.
And as you didn't work in a lab, all of your research was on paper or the internet or interviews, correct?
Yes.
And could there have been a bias in the sources that you chose to read and use in your research?
I conduct research so extensively to prevent that bias, so no.
But hypothetically, could there have been a bias?
No.
And you work for Rationalist magazine, correct?
Yes,
And they pay you salary, correct?
they do.
And your editor picked you to write an article about DRUFO.
Yes.
And and Rationalist is a magazine devoted to resisting the spread of pseudoscience.
In other words, to seek the truth.
And your articles are written to aid in this idea of resisting the spread of pseudoscience?
Of course.
And you believe that the link between cancer and DRUFO is pseudoscience?
It's blatant.
And you're testifying on behalf of DRUFO and Lush today, correct?
Yes.
And your article was, as your editor told you, to write in favor of DRUFO, correct?
My editor just brought the concerns and told me to write about DRUFO. It was the research that led to the in favor verdict.
And talking about Haven Landscaping now, you didn't work at Haven Landscaping, correct?
I'm allergic to grass, so no.
So you only can speculate about what actually happened or what your sister told you, correct?
Well, I lived with my sister, so I got a pretty good understanding.
I'm sorry, that was a yes or no question.
Can only base my conclusions off of what I've heard or researched.
Thank you. And your research on DRUFO was part of a series on modern agricultural technology, correct?
Yes.
Not just on DRUFO, correct?
No, DRUFO was just an article.
And your sibling was exposed to DRUFO, correct?
Yes.
But you weren't exposed to DRUFO
No, I was not.
because you didn't do landscaping, correct?
Yes.
And Dakota said that you did everything together. Is that true?
When we were young, we did.
Everything except be exposed to DRUFO, correct?
Not quite. As soon as Dakota started taking a job at Haven, our lives kind of separated.
And you're testifying against your twin sister, correct?
Unfortunately.
And you said in your statement that DRUFO is an effective pesticide, correct?
Makes it revolutionary.
I'm sorry, can you repeat that?
Yes.
Okay. And pesticides are poison by definition, correct?
Well, DRUFO is a little different than that. Most pesticides are, however.
I'm sorry, to clarify for the jury, you did say that DRUFO is an effective pesticide, correct?
Yes, but DRUFO isn't like other pesticides. It's not poisonous.
But if pesticides are poison by definition, DRUFO is a pesticide. Aren't pesticides poison by definition, correct?
Pesticides are designed to kill weeds. DRUFO does that as well.
Let's talk about agricultural technology. You said that besides the US government, you have the best knowledge of anyone. Isn't that true?
Overall perspective, not in a specified field.
And your research was only on paper, and you found out more knowledge than scientists that have been working for far longer than a year with the actual product in a lab.
I referenced the studies by those scientists.
So you're secondhand.
Sorry, could you repeat your question? You cut out.
So you're a secondhand researcher?
As any journalist, I research the information that is accurate.
You could have had a bias in these sources that you used as you didn't actually work with the chemicals, correct?
I have no bias, counsel.
No further questions, Your Honor.
Ms. Burton, redirect briefly, if you may.
Yes, Your Honor. Before I begin, I understand that it seems like we have a hard stop at 7, as that's only 2 minutes away. We were just wondering what will happen at that time for proceeding.
Do we have, let's see, Ashley, Amber, are you with us?
I sure am.
Okay, who are we going to lose at 7?
We have one of the scoring panelists that has a hard stop at 7. I've already spoken to the CBA, so we have a backup plan. So we just go ahead and proceed. We just need to be aware of the time.
If we have 3, we're all right.
Yes.
If we get down to 2, I will score in retrospect. I can do that.
Awesome. Great. Thanks, Your Honor.
Let's go ahead.
Sounds good, Your Honor.
Doesn't
Now-
give you license. It does not give you license to be long-winded.
Of course not.
Okay.
Now, Mr. Weirs, opposing counsel just talked about bias. Do you have any bias in today's case?
Absolutely not. All my information is just based on the facts.
And is that the true goal of the rationalist?
Exactly. To seek the truth despite the controversies.
So opposing counsel also talked about pesticides. Now, how is Drufo different than just a pesticide?
Well, most pesticides contain known carcinogens like arsenic, but Drufo doesn't have any of those chemicals, making it much safer to the users.
And was that the main goal of what the rationalist was researching?
The main goal was to determine whether lush fertilizer and by extension Drufo was safe. That was something that wasn't covered during the research.
Thank you, Your Honor. I have no further questions.
Mr. Cooper, recross.
Yes, Your Honor, I have one question.
Then let's ask it.
Well, according to these things, Drufo was supposed to be great and all these things like you just testified, but you still were assigned a certain position by your editor to write in favor of Drufo, correct?
No, I wasn't.
No further questions, Your Honor.
Thank you very much, Mr. Weirs. You are, your testimony is completed. You are excused. Let's have the last witness for the defense. Ms. Brennan, looks like it's your witness.
Yes, Your Honor. The defense calls Blake Doncourt to the stand.
And Ms. Holobeck, it appears you are doing cross. Let's call your witness and let's proceed.
May I proceed?
Yes, you may.
Good evening. Please introduce yourself to the jury.
Good evening. My name is Blake Doncourt, and I'm the CEO of Lush Fertilizer. I want to say that it is a tragedy that this happened to Ms. Dakota Weirs, and it's precisely why I founded Lush Fertilizer.
For the record, have you been here throughout testimony today?
I have.
Was there anything in particular you noticed that was concerning about Ms. Weir's testimony?
While I knew that Ms. Weirs was working with other chemicals during her time at Havens Landscaping, I'm still concerned that even now, we don't have a list of these chemicals or their side effects.
Why is that concerning?
As you've heard, there are a lot of agricultural products that are dangerous, and it's important to know which ones that she was using. It's because of those dangers, both to humans and the environment, that I started working on Drufo.
Can you elaborate on that?
I wanted to create a revolution in the agritech industry. I knew that there were truly dangerous products out there, and we were also destroying the planet with the overuse of fertilizer. And Drufo solves every one of these problems.
So how did you go about creating Drufo as a young entrepreneur?
Well, we had to start by synthesizing the compound itself. Then we spent years on research and development for its effectiveness and safety. After countless hours and a rather significant amount of capital, we finally had a product ready for the market.
Did any of that research and development ever include any safety testing?
It did. I would never release a product to market if I had any doubts about its safety.
To your knowledge, did any of that safety testing ever show a link between using Drufo and being diagnosed with cancer?
Not only did our internal studies not show that link, there are in fact no conclusive studies showing a link between cancer and the use of Drufo.
Now, Ms. Durst brought up a lot of her concerns earlier. Were you ever made aware of those concerns prior to today?
I was not. Ms. Durst had every opportunity to bring her concerns up to her direct supervisor, Jerry, or my personal attention. It was in fact her job, but she never brought up any of the concerns that she had until today.
We also heard about an email that was sent supposedly from upper management to other people in your company. Did you ever receive such an email?
I never received such an email.
Now, were you within all federal requirements with Drufo?
We met all federal safety standards for our product to be sold here in the US.
Now, despite meeting federal guidelines and having your tests come back negative, did you still place warnings on the packaging of your product?
Yes, there are in fact several user recommendations on our product.
We've seen the packaging several times today, but can you just summarize what some of those warnings are?
Well, you can see on the right-hand side here, it says to utilize protective clothing that covers any exposed skin, wear a respirator or N95 rated mask, and it also states to keep out of reach of children.
Based on Ms. Weir's testimony earlier, did she follow those guidelines?
No, she didn't. She misused not only our product, but every product that she worked with at Havens Landscaping.
Should she have even been using the product in the first place?
No, Ms. Weir should not have. Havens Landscaping shouldn't be hiring children to work with chemical fertilizers and should most definitely be monitoring their employees to make sure that all of the recommendations are followed.
Thank you. My trial technician can now take that exhibit down. How do you feel about the allegations that have been made against your company?
All the allegations are predicated entirely on misinformation.
Now, we've talked about misinformation. We've talked about how Ms. Weir's misused the products she worked with. Is this lawsuit misguided in your opinion?
This lawsuit is entirely misguided. We conducted test after test after test, showing that our product was safe. So there is absolutely no way that Ms. Weir's use of Lush fertilizer was the cause of her cancer.
Thank you, Your Honor. I have no further questions at this time.
Ms. Holbeck, cross-exam.
Yes, Your Honor. Mr. Doncourt, your company is the creator of the product known as Drufo, correct?
Yes.
And you stated in your statement that since 2000, you have grown the company from an unknown producer of fertilizer to one of the world's largest supplies of yard commercial fertilizer.
Objection.
I'm sorry, the objection is?
This is improper impeachment. It's Rule 613.
Your Honor, I am not impeaching this witness.
Yeah, so far I haven't heard impeachment. Let's get the question and the answer out. Please restate the question.
Of course. And you stated in your statement that since 2000, you have grown the company from an unknown producer of fertilizer to one of the world's largest supplies of yard and commercial fertilizer.
Through a lot of hard work, both for me and all of my valued employees, yes, we have.
And you started developing Drufo in 2000, yes?
We actually started development of Drufo in 2000.
So just to clarify, you started developing your flagship product during the lowest financial point in your company?
I mean, the company had to start somewhere. So yes, we started development of our product so that we had a product to market.
And at this time, Lush Fertilizer was responsible for testing the safety of this product, yes?
Yes, it was over a course of years after it was first developed.
Also at this point in time, you were sent an email concerning the risk of Drufo, were you not?
I'm sorry, could you restate your question?
Of course, my apologies. Also at this point in time, you were sent an email concerning the risk of Drufo, were you not?
I was not.
Please refer to Exhibit 4. Your Honor, my co-counsel is sharing on the screen a copy of Exhibit 4. Is this the email sent to the leadership of Lush Fertilizer Incorporated?
No. Not only have I never seen this email, which is weird considering that I'm supposedly a recipient, we also turned over our mail servers to the plaintiff attorneys and they couldn't even find the email. The only person that has ever seen this email is Carson Burks.
I understand that, Mr. Doncor. Please just follow me along with the rest of these questions. Is this your name in the address section of the email?
Yes, it is.
So, and this email contains information regarding the potential carcinogenic effects of Drufo?
Yes, it does.
And you are listed in this email as receiving it, correct?
I am listed, but again, I never received this email.
I understand that, Mr. Doncor. Once again, just follow along with me with these questions. Is the email in front of you marked as unread?
Yes, it is.
So you were sent an email about the safety of Drufo and did not read it?
I'm sorry, could you rephrase your question?
Sure. So you were sent an email about the safety of Drufo and according to this exhibit, did not read it?
I was never sent an email about concerning the safety of Drufo.
Okay. Yes or no, did you see this email prior to the investigation of your computer systems?
No, I didn't.
So it is your position today that you have not seen this email?
It's my position that this email is entirely fabricated.
Is it true that you've received other reports like this?
Never so blatantly saying that our product caused cancer. All of our reports showed that it was perfectly safe.
Mr. Doncor, I do not believe that was my question. My question was, it is true that you've received other reports like this?
All of our testing showed that our product was safe.
Mr. Doncor, I don't believe you're understanding my question. I'm asking if you've received other reports like this, such as other emails.
No, I haven't.
So you didn't receive any emails at your company?
I did, just never giving the information that you're saying.
Okay. Is it true that this email could have been sent to you and you did not read it?
No, I'm very diligent about reading my email.
But just to clarify, you are a very busy businessman, correct?
Yes, I am.
So it couldn't have been possible that maybe it was sent to your secretary and just not sent to you? You just happened to not read it because you were a busy businessman?
No, had this email been sent to me, I definitely would have read it, but this email was never sent.
Okay, let's talk a little bit more about your company's research on the safety of Drufo. You stated in your statement that there was little to no risk to persons using your fertilizer, correct?
It is correct.
Let's drop Exhibit 4, please.
Is it true, based off your previous answer, that there is some risk involved in using Drufo?
There is little risk in everything that we do. We can't eliminate everything, and we did the best that we could in ensuring that our product was as safe as possible.
So just to clarify, was that a yes or no answer to my question?
Our product is as safe as possible, but just like anything in life, there is minuscule amounts of risk.
Let's talk about the testing done on your product. You do not bake any of your products, correct?
As is not deemed necessary, we don't.
Is it true you do not bake your products because it is too costly?
For the limited risk that it alleviates.
Your Honor, let the record reflect that my co-counsel is sharing on their screen a copy of what's been pre-marked as Exhibit 8. Would you please identify the document in front of you?
That is an amortization table that I made back in 2004, showing projected profits both with and without baking.
Is it true and accurate to the best of your knowledge?
Yes, it is.
Your Honor, at this time, I move for the admission of Exhibit 8. Its authenticity has been stipulated to and its accuracy shown.
And Ms. Brennan, any objection to 8?
I have no objection, Your Honor.
8's in. Ms. Holobeck, you may continue.
This exhibit shows the 6% and 2% increase in profit if you do not bake your fertilizers, correct?
Yes, it does.
Is it true that in 2004, it only cost $250,000 to bake your fertilizers?
That was our estimated cost, but it would increase over time.
Is it also true that in 2004, your income profit was $1,657,000?
That was our profit at the time.
Would you agree with me that's a very large gap in money?
Running a company that size, it only covers so much.
And based off this information, you still decide not to bake your fertilizer.
It wasn't the need to, so no, we didn't.
Okay. I'm just going to talk a little bit more about your this money that you did not spend. This money that you did not spend, it had to have gone towards something, correct?
Mostly being reinvested back into the company to continue growing.
Right. And part of reinvestment is distributing it to shareholders, correct?
Yes, that is part of how company functions.
And aren't you a shareholder in your company?
I am a shareholder along with several other people.
So part of this money that you did not spend actually went back into your own pocket?
A small portion, yes.
No further questions, Your Honor.
Ms. Brennan, redirect.
Yes, Your Honor, but first may I inquire as to how much time I have remaining?
You have 1 minute and 32 seconds.
Mr. Doncourt, why didn't you bake your fertilizer?
Baking fertilizer only would have worked to alleviate any risk of cancer. A risk of cancer was never identified as a risk from using our product. Therefore, baking it wouldn't have done anything. It wasn't necessary.
Opposing counsel talked about where the additional money goes. Do you donate any of your profits to charity?
We donate 10% of our annual income to various charities surrounding environmental action.
And were you ever made aware of any concerns regarding your product being carcinogenic, whether through email correspondence or otherwise?
No, I wasn't. All of our tests and all of the reports I was shown showed that our product was safe for consumers.
Thank you, Your Honor. I have no further questions.
Ms. Holobeck, any recross?
Yes, a brief one, Your Honor. Mr. Doncourt, does this excess money that you decide not to spend, it's not part of your income, is it?
I'm sorry, could you rephrase that question?
Of course. So you have an income, correct?
I'm paid a salary from the company.
Right, and part of your salary, that's the part of your money that's going to your oceans and that 10% of charities, correct?
No, 10% of Lush Fertilizer's profit goes to charity.
Right. So this $250,000 that you did not spend, that's not actually part of your profit.
$250,000 would have been the cost of baking our product.
Right. And that money is not technically a part of your profit, considering you did not make any money off of it.
It would have been an expense.
Right. So in fact, the $250,000 to bake your product didn't actually go towards the 10% of your charities.
We didn't bake our product, so that money didn't go anywhere really.
No further questions, Your Honor.
Thank you. That concludes the testimony of Mr. Doncourt. You are excused. Any additional witnesses for the defendant?
This time the defense rests, Your Honor.
Thank you very much. We're going to move immediately into closing. For the plaintiff, we will have closing from Ms. Holobeck.
Your Honor, before I begin, I would like to reserve any remaining time I have for a rebuttal.
Yes, you may. If you don't use it, it's for rebuttal.
Your Honor, opposing counsel, and members of the jury, how much is one life worth? The defendant, Lush Fertilizer Incorporated, and their representative, Blake Doncourt, created the product known as Trufo. This dangerous product caused the plaintiff, Dakota Weirs, to get non-Hodgkin's lymphoma. So I ask, how much is one life worth? Earlier today, my co-counsel presented evidence regarding the multiple tests done on the product Trufo. I would like to explain these tests a bit further and examine specifically the results of these tests. Simply put, Carson Durst found conclusive evidence that Drufo could causes cancer in rats and could potentially cause cancer in humans. Additionally, Dr. Casey Rogers found a correlation between Drufo and cancer and stated that Dakota Ware's symptoms were consistent with the ones found in her study. As you have heard, both witnesses found correlations between Drufo and non-Hodgkin's lymphoma, and yet Lush Fertilizer paid no attention to it. However, these are not the only facts that prove Lush Fertilizer's negligence. Skylar Wares, the defendant's own witness, stated that Drufo, by definition, is a poison. This was backed by the testimony of Dr. David Williams, who stated that not only is Drufo banned in the EU, but that Drufo contains nitrogen, which is a known carcinogen. If the defendant doesn't even listen to its own company's concerns about a product, then why would they be concerned about the safety of their customers? Based on jury instruction number 3, the defendant did not exercise reasonable care. Blake Doncourt wanted to wait till he was 100% sure that Drufo could cause cancer before he would spend money to make it safe. He blatantly stated that the reason his company does not bake its products is because it's too costly. Let me remind you that baking their products would remove any question on whether Drufo was carcinogenic. On top of this, he was banking on the success of Drufo to build up his company in its early years, which resulted in multiple cut corners. It was Lush Fertilizer and Blake Doncourt who put the price tag on Dakota Ware's life. Members of the jury, the plaintiff has the burden of proof in this case. The plaintiff has to prove that the defendant, 1, manufactured a fertilizer product containing the chemical compound known as Drufo. 2, was negligent by failing to exercise reasonable care to prevent an unreasonable risk of harm to persons who might have been reasonably expected to use the product. 3, the plaintiff was one of those persons the defendant should have reasonably expected to use the product. And 4, the plaintiff had damages that were caused by the defendant's negligence in a manner the defendant should have reasonably expected while the product was being used. We have done this. Blake Doncourt has already testified to the fact that his company is the creator of the product known as Drufo. His company decided not to bake their product, put any warning labels on their packaging, and ignored and hid the dangers of Drufo. As for contact, Dakota Wares continuously encountered Drufo during her time at Haven Landscaping, which resulted in her chronic illness, non-Hodgkin's lymphoma. This chronic illness caused her to lose her full ride scholarship to Juilliard and causes her father to pay extensive medical bills. Members of the jury, it was the defendant's product that was rushed onto the market. The defendant's product that was not baked properly. It was also the defendant's product whose testing results came back inconclusive, resulting in a second study, and so much more. So I ask you, how much is Dakota Ware's life worth to you? Please return a verdict finding defendant negligent. Thank you.
Thank you. And for the defendant, closing, Ms. Burton.
Yes, Your Honor. Before I proceed, may my trial technician have permission to share exhibits that have already been admitted into evidence, as well as the jury instructions I am referencing on the screen during my closing?
Yes, you may.
With that, Your Honor, I'm ready to proceed. May it please the court? Misguided, misinformed, and misused. Lush Fertilizer does not cause cancer. By now, that much should be very clear. Lush was created to provide a safe alternative to the products made by the nefarious giants of the agritech industry. You heard today that Lush Fertilizer started out mission-oriented and has always prioritized their customers. You heard about the extensive research and testing they put their fertilizer through before ever releasing it to the market. And you heard that Drufo was never meant to be used by children, let alone in the way that Miss Weirs used it. Misguided, misinformed, and misused. Today, the plaintiff's case is misguided about the pseudoscience presented as fact. misinformed about the true effects of Drufo, and based on the plaintiff's misuse of Lush fertilizer? Well, she was just a child. Now, in today's case, we do agree with what some of the plaintiff has said. We agree that Lush fertilizer contains Drufo, and we agree that this, Exhibit 1, is the product label. But most importantly, we agree that what Ms. Weirs has gone through is a tragedy that no person should ever have to experience, but it ends there. Because we didn't cause Ms. Weirs' cancer, other chemicals did. Keep all of this in mind when determining your verdict today, but also ask yourself these questions. The plaintiff never provided a list of the other chemicals Dakota worked with or testified to researching their effects. Why? They never called another employee from Havens Landscaping to talk about company procedure or conduct. Why? And this is the first time in 15 years that Carson Durst is ever bringing up concerns. Why? Misguided, misinformed, and misused. The first place to begin today as the jury is determine whether the plaintiff has met their burden. Because if they have not met their burden, then you do not need to go on to determine whether we have met ours. Jury instructions number 2 and number 3 outline this burden, which they had to prove by a preponderance of the evidence. However, they failed to do so for 4 main reasons. 1, they did not and could not provide a link between non-Hodgkin's lymphoma and Lush fertilizer. 2, people who work in the modern agritech industry are reasonably expected to know the products they work with are dangerous. 3, the product was not used in a reasonable manner that would be expected. And 4, it was never meant to be used by children. Now, keep all of that in mind, but even if you determine that the plaintiff has met their burden in today's case, the second step is to go on to determine whether Dakota's own negligence contributed to his condition today. Jury instructions number 8 and number 9 outline this burden, which we have proven by a preponderance of the evidence for 2 main reasons. 1, Dakota ignored safety recommendations on Lush fertilizer's packaging by not wearing protective clothing. And 2, even the plaintiff's own expert witness recommends wearing protective clothing when working with the products. The plaintiff today asked you, how much is one life worth? And even though we agree that it's invaluable, the real question is who has to pay? Lush Fertilizer has always prioritized their customers and never put their lives above profits. At the end of today's case, they are not liable. Sign your verdict form affirming the plaintiff did not meet their burden and find Lush Fertilizer not liable. Thank you.
Thank you, Ms. Holobeck. Any rebuttal for what time is left for the plaintiff?
Yes, Your Honor. Can I refer to my timekeeper as how much time I do have for a rebuttal?
Yes.
You currently have 1 minute and 5 seconds.
Thank you. May I begin?
Yes, you may.
Members of the jury, the opposing counsel has tried to convince you of 3 facts: that our case is misguided, misinformed, and misused. For misguided, they claim that we are rejecting pseudoscience. Pseudoscience is the questioning of actual science. Of course, it should be rebutted because it's not actual science. Science has proven today that there's a link between Drufo and cancer by multiple witnesses. Misinformed? The only reason Dakota wears to not wear her protective equipment is because she didn't know it could cause danger. If Lush Fertilizer had merely put a warning label on their packaging, she would have worn her protective equipment because then she would have known it was dangerous. The whole point of a company is to protect customers, and they did not do this. As for being misinformed, Carson has tried to bring up to Mr. Doncourt multiple times that her concerns about Drufo, and Mr. Doncourt turned a blind eye. Didn't want to spend the minimal amount of money it was to make his safe. Thank you.
Thank you. The case stands submitted. Thank you very much. When the scoring panelists have submitted their scoring sheets, please activate your video. That way I'll know that they're submitted. If I could have all the participants on camera, please. And all the rest.
Sorry, mine are technical difficulties.
There we go. We've got the majority of the people at least. Okay. And I've got one scoring judge. I want to say at the outset, all time considerations about how long this has taken, and this was a long one. A few technical problems, but primarily it was because of my getting involved in these legal discussions. And I'll tell you, it's always the judge's responsibility to keep things on time. Harry Truman, I can't remember the number of his presidency, maybe 35, I can't remember. President Truman had a sign on his desk that says the buck stops here. And the buck always stops with the judge. It's never the fault of the attorneys, the witnesses, or anyone else if things run long. It's my responsibility. But I will tell you, the reason that I got involved in this is because it was involving. It was outstanding. I have done a lot of these. I've been judging these competitions for 16 years. And this was a good one, a really, really good one. You should all be proud of yourselves for making me run this long. I could have cut you off, but I didn't. I probably should have, but I didn't, because I got involved in this. So congratulations on that, if nothing else. We've got, let's see, I've got Ms. Porter, Mr. Ingram, and do I have my other score here? Not, do I still have a third score? I hope. Do I have?
We received her her score sheet, so.
Ms. Busby? You got one from Ms. Porter, Mr. Ingram. Did you get Ms. Busby's?
Let me double check. I believe Amy
Because
said
if not, I will do one.
we have all of the score sheets.
Okay, good. Ms. Porter, Mr. Ingram, if you've got time to give some comments, that'd be great. If not, you can drop out. Again, I apologize to you as well for running this long. As I said, the reason being I got involved in it. And I thought it was incredibly interesting and well done. Ms. Porter, what do you think?
I absolutely agree. I thought this was an excellent round all around. I have two very quick pieces of feedback because I know we've been here for almost 3.5 hours. So I'll let you all go eat dinner. I think this happened on both sides, is that you called other witnesses either by their first names or just by their last names. I think you want to call them by their title and their last name. So it's Miss Weir, not Dakota, because especially if they're the plaintiff and you're the defense, it's a little weird to be calling them by their first name. I know they're 20, but that's I think you would want to be calling them Miss Weir. I think even if they're your client, you probably want to call them Miss Weir as well. And then I think this was also a thing, and I know that there were, the placement of the cameras all around was like, tough, couldn't change that, but just make sure you're making eye contact with the actual camera. I think that's something that you can work on between now and tomorrow. I know maybe you had the screen up that showed what the other witnesses, but make sure that you're looking directly into your camera. I know that's tough, but make sure you're doing that, because especially if you end up looking down or you want to go look at your witness, it makes it start to look like you're reading. So those are my two quick pieces of feedback, but it was a really great round. It was a lot of fun to watch.
Yeah, I'd echo all of that. Great feedback. Also, just an absolutely phenomenal round. My one piece of feedback in terms of improving for tomorrow, because I know you guys seems like you're probably both going to be fighting for that last spot, is listen really closely to what the judge is saying. And this is the hardest thing to do as mock trial competitors, because we've been practicing this material for months, right? But listen to what the judge is saying when he rules on those objections or when he asks you to respond to something. Because if you can, if you say something that you've said before but doesn't quite match up with what the judge actually asked you, we can pick up on that pretty easily. And conversely, if you can respond to exactly what he said, then that wins you points really easily. And then on the defense, if we could just get, this didn't affect my scoring, but if we could get that witness table a little closer to the camera so I could see those witnesses, that would be really nice. But both teams were fantastic. Good luck tomorrow.
Thank you. I support everything that the scoring panelists have said. And again, this was so involving that it was just real interesting. I was really glad to do this one. Thank you very much. So good luck tomorrow, and thank you. And Amber, if you're still on, I'll chat with you for just a moment.
You bet. Thanks, everybody.
Hey, you guys.
Thank you.